Side, Your Lordship. The item number 22 may come after view vacation examination. The content matter.
Who is appearing on the other side?
He.
Mr. R. Muzumdar, the learned counsel, appearing for the petitioner. Praise for adjournment of the matter. He has already obtained the consent of the other side. Let the matter be fixed after the ensuing view vacation.
Oblige, Your Lordship.
With due consent of others, I beg to item number 30.
30.
30. Though yesterday I have given the adjournment slip.
Okay.
The engaged counsel D. Boda is out of station.
Okay. Mr. So-and-so, the learned counsel, appearing on behalf of Mr. D. Boda, the conducting counsel of the case, prays for adjournment of the matter. He has already taken the consent of the other side. Let the matter be fixed after view vacation.
Lordship, I beg to mention item number 21. The CD perhaps is not received.
Okay, right. The learned counsel appearing for the accused applicant subject the case is yet to be received. Let the matter be listed after the view vacation. When do you want it?
After vacation,
Why after vacation?
before
AB matter.
before the matter.
Bills cannot be, I mean, let the matter be listed on
8 or 7.
okay, 7th of April.
7.
I'm obliged.
So post earlier shall continue till the next date.
I'm obliged.
Within instruction from my client, I want to do this matter now.
Okay. Mr. So-and-so, appearing for a petition, submits that he has instructions to withdraw the matter. The matter is dismissed on withdrawal.
Obliged.
May I please, Your Lord?
Yes.
My Lord, this application was heard on the earlier day, my Lord. The second application in the NDPS case.
Yes.
Lordship, my Lord, asked whether, my Lord, time of detention is a new ground or not, my Lord. So, my Lord, today is, my Lord, about 2 months in custody. But quantity is commercial quantity, my Lord. So, I have not got a decision, my Lord, where this small period is a, my Lord, period of detention or not. And another thing is that, my Lord, on the earlier petition, my Lord, we have not taken that ground that, my Lord, this petitioner is a public servant. And
No, it was there.
It
was
not,
there. He was working for this laboratory or some laboratory, right? He's
my Lord, petition which I have seen, my Lord, that ground I didn't find, my Lord. Earlier petition, my Lord.
But I think we have in the rejection we have written something about his job profile.
And my Lord, twin ground, my Lord, that whether I am involved with the, my Lord, with the allegation, my Lord, made in the affair. And also, my Lord, that, my Lord, in the future, my Lord, I will not commit such crime, my Lord. Those two in condition, my Lord. Whether being a public servant, my Lord, he has already been suspended. And, my Lord, whatever, my Lord, these drugs, my Lord, were found, my Lord, it was found from the, my Lord, the house of the, my Lord, accused number 1. He is Shah Jahan Ahmed.
Yes, Mr.
Already, my Lord, idea of question, my Lord, decided, my Lord, all this ground.
Okay, we'll consider Mr. Chaudhary. I will pass the order.
My Lord.
We'll consider your
My Lord,
submissions.
I am obliged, Lordship.
See?
But I am appealing for the private lawsuit. Another connected petition lawsuit. On same subject matter is pending lawsuit. It may be taken with that.
No, it has been listed for sending it to the mediation. You want to say, you want this to be sent to mediation?
Petition.
Okay, we'll take it up after some time. Who is appearing for the other side?
Rita Devi.
I think this matter cannot be referred to mediation. As my friend said.
Due to selection and appointment of the BSF Miller.
It may come up for the admission.
Mr. A. Motin, the learned, A. Mohammed, the learned counsel, appearing for the petitioner. You are appearing for the other side?
CCP and
Okay. Also heard Mr. S.S. Roy, the learned CGC for the respondents. The counsel appearing for the parties submit that this matter may not be sent for mediation. May not be sent for mediation as due to the issue involved in the instant case. Let the matter be listed. Let the matter be listed for admission in usual course.
Obliged.
Mediation.
My lord, cannot be dismissal from service, government employee.
Hmm.
Appeal was done, appeal dismissed. The mediation cannot be solved, my lord. This one. 24 matter and
Mr.
dismissed for
PK Roy,
service,
yes,
came up for hearing.
it will come for a hearing only.
Hearing, my lord, within a time, 1 month, my lord, because
Heard Mr. PK Roy Choudhury, learned counsel for the petitioner, also heard Mr. T. Chutia, the learned additional senior government advocate for the respondents. The counsel appearing for the parties submit that this matter should not be sent to the mediation as no fruitful result can be achieved from mediation. Full stop. In view of the aforesaid submission, let the matter be posted for admission hearing in usual course. Mediation, we'll send it for mediation.
yes, sir.
Who is appearing for other side?
The Women and Child
Hmm?
the Women and Child Development Department is the primary respondent.
Mr. Chutia, you are appearing?
Women and Child Development.
You are appearing, Mr. Chutia?
Yes, sir. I am appealing for respondent number 126.
126.
Yes, sir. That one, that's good, yeah.
7. So we'll send it to mediation. Heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr. T. Chutia, the learned additional senior government advocate for respondent number 126, as well as MS. Your name, please? So-and-so for respondent number 7. Let the matter be sent to the mediation center, Gauhati High Court, for mediation. Full stop. The mediation center will do the needful about listing of the matter before a selected mediator. Full stop. Endeavor should be made to resolve the matter before the mediation center within a period of 2 months.
Much of.
Yes, can it be sent to the mediation?
My lord, they make a minute.
But other side is not there. Who is the petitioner?
Earlier, Mr. Mr. Sharma.
RJ Sharma.
Thereafter, it taken up that brief from Sharma to, and they took out to Mr. Gupta. But because he, the petitioner submitted resignation and accepted and struck off his name from the roll. And thereafter he,
Okay, you write none appeared for the petitioner. Petitioner, however, Mr. A.K. Datta, the learned counsel, learned CGC for the respondent numbers 1, 2, 3. And then others you write to mediation. Send it to mediation.
it may not solve the.
It will not solve. That's what I'm asking, whether it can be sent or not. Then we'll wait for some time. We'll wait for some time, let him come. If it doesn't come, then we'll see whatever is to be done.
This matter cannot be taken.
Okay,
Yes,
the
sir.
counsel appearing for the parties submit that the matter may not be sent to the mediation as the issue involved may not be resolved before the mediation center. Let the matter be listed for admission in usual course.
May I please, Lordship, my synerging legs, 10 passport for time being, my lord.
Okay, pass out for time.
My lord, NNB should raise its own leg, my lord, for the time being.
Okay, time being crossed.
Item 10 and item 40.
May it please the Lordship. Lordship, this is a matter, Lordship, it pertains to an elephant which has been kept in Tamil Nadu for a period beyond the permit. Lordship, in this matter, we have filed an IA on the last occasion because, Lordship, the representation of the state of Assam was not proper.
So you have filed an
We
IA.
have filed an IA, Lordship, item 34 of the supplementary.
30 put IA, give me the IA. Is it the chief secretary or he can represent
Lordship,
commissioner and
the
secretary?
commissioner and secretary, Lordship, for implement of the commissioner and secretary as the Lordship.
Whether he can appear? I mean, have you seen the provisions?
Lordship, because
The
earlier.
state can be represented by who?
Lordship, commissioner and secretary of the department, Lordship.
Yes, who is appearing for respondent number 11?
Yes.
I am a Miles. Your Lordship will permit me to appear
I
by
can
this.
see it, I can see it, I can see him. Don't connect us. How will I see this? Visit to the set and if I let a Excel cover. Okay. Yes, yes.
Your Lordship may permit me to appear by
They
VC.
they want to implead him. I mean, I mean, do you have any objections to that?
Yes, I have objections, Your Lord. I
Why?
will accept notice. Your Lordship will give me 2 weeks time, I will file
No,
the
what is to
reply.
be replied to? What is to be replied to in this?
May I indicate,
See, this is an important matter where like there are certain implications, sentiments are involved, and like they want to bring in a person who is supposedly to be represent the state. And what is the problem in that?
The very first thing is, if Your Lordship will look at the index of the application, what is filed is an application supported by the affidavit, and there is no wakalat of the person concerned supporting this application. Very first objection.
I didn't hear you. What?
They say the secretary in the department should be permitted to represent the state of Assam. Maybe all right. But there is no wakalat by the secretary as far as this matter is concerned.
Wakalat, you haven't filed wakalat.
There is no wakalat.
No, wakalat will be in a different file. I mean, wakalat will not be sent to you.
I have no idea about whether they actually filed it or not, I don't know.
No, here procedure is a little bit different. Actually, wakalat is not sent usually. So
Okay.
wakalat will be in a different file.
Number
So they
two,
said that they have filed a wakalat now.
very well, I accept that, Number two, there is no affidavit supporting the averments in the writ petition. What they have filed is an affidavit of the secretary in support of the application. He has to affirm to an affidavit supporting the averments in the writ petition. That has not been done. In the absence of that, merely this application cannot have the effect of the secretary representing the state. That also has to be rectified, If Your Lordship will look at the affidavit,
Yes. See, I mean, he has taken an objection saying that, I mean, he may be justified also because see, I mean, now he will be representing the state. Now, one second. Now he has to affirm the statements that has been made in the writ petition. Correct, but this petition is only for I mean, affirming the statements made in this IA, not in the writ petition. So that is what he is saying.
The Lordship applicants,
So,
2 and 3, they're already the petitioners, Lordship.
They must rectify it. It is not that I have any objection for somebody representing the state of Assam in a proper manner. Then, one more thing, if Your Lordship will look at para 1 of the writ petition.
so let them, you are Mr. I didn't get your name.
Maria Arpudam,
Yes, like one thing they can
my
do. See,
name is
these are small technicalities. And another thing is that once this is allowed, he will be a party in the writ petition. Then they can file an additional affidavit also affirming the statements that has been made in the writ petition. That can be also done. So, I mean, why, I mean, like keep this matter pending for these small issues? The matter should be finally heard. I mean, that is what the intention should be from the parties.
I paper instead of Tamil Nadu. Would like some time to.
Why do you need a time here?
Would like to acquire instruction from that instead of Tamil Nadu.
Why do you need instruction? What instructions you need? These are all legal issues. But if you are aware, then why are you making what instructions you want from Tamil Nadu?
We have the copy only yesterday. We will have to forward to the state.
Okay, we'll give them some time, Mr. We are giving some time.
Very well,
I mean, we will not issue notice. We will let them take the.
I will accept notice, I am not on the formality, but whatever application is filed, once Your Lordship allow, it should have a meaning and should serve the purpose for which application is filed. And they will also have to amend para 1 of the writ petition, if Your Lordship.
Okay, I have to number 8. We have no objection in the
No, he is having problems. I mean, I don't know why. I mean, that issues have been raised. I mean, only impleading the party. What is there? I mean, earlier state was represented by somebody else, and like there was objection raised. Now they are trying to bring in the correct person. Then what is the problem in that?
That is very much true, Your Lordship, but since we are representing a state, Your Lordship, it's very well incumbent on our to acquire the. The matter of verification, first of all, on Monday, Your Lordship, can be expedited. Monday,
See, this thing, these are, I mean, we are not staying in the days of Nalanda, correct? We are staying in, digital world now. I mean, you don't need 1 week time to get instructions from Tamil Nadu. Whatever you need to take it by Monday. We'll post it on Monday. On the prayer of the council representing representing the parties, let the matter be fixed on Monday. Monday we'll hear this. We will dispose this.
Deeply obliged.
Whatever instructions you want to take, you take it by Monday. Release the matter on Monday.
Deeply.
Lordship, in item number 11, WPC number 5764, I am the petitioner.
Hmm?
In the other one, I am the respondent.
Yes.
Lordship, in this writ petition has been filed. That is item number 11. That is WPC number 5764/2023. This is filed by the petitioner for implementation of the award that has been passed by the insurance ombudsman.
Hmm.
That award is at page. It starts from page 69. 69.
Who is appearing for the insurance?
Lordship. He went just outside. He's there. Mr. Argusam is there.
This should have been put a little bit of sideways. Okay, you need to put it to the side. 1 second. No, 1 second. Put it on flat, cool, but देखा था मैंने। Yes, that will do. Now we can see. Yes, you are appearing for the insurance. You are appearing for the insurance.
Yes, sir. I also filed a petition.
Now you are appearing for respondent number 2 and 3.
Wait.
And who is for respondent number 1? You are for respondent number 1. Okay.
Lordship, the award of the insurance ombudsman, it starts from page.
So you are challenging that, right?
No,
Award.
Lordship, I am praying for implementation of that, and they have in the other item number 12, they have challenged that order as because the IDV, that is insurance declared value, was enhanced by the insurance ombudsman
Okay.
more than what has been.
So
stated in the-
whatever you, ombudsman has given, you are fine with that.
Yes, Lordship.
You are agreeable. You are happy with that.
Yes.
The only thing is that they are saying that, this has been enhanced
Enhanced
from the award, from
Yes.
the initial award.
Initial contract.
Initial
That is
contract.
the insurance policy.
Okay, it has been enhanced from the insurance policy. What about
Yes.
the coverage that has been enhanced by the ombudsman?
Yes.
And they are not agreeable to that.
Yes.
That insurance company is not agreeable to that.
Agreeable to the enhancement that has
Correct,
been
correct.
made
Got-
by
got
the
it, got
in
it,
the
got it.
IDV.
Got it, yes.
That is the
Mm, mm.
Lordship. There was an accident,
Mm.
and thereafter the insurance claim was raised,
Mm.
and in between, they went for salvage by. They
So
fought for
insurance
salvage
cover
bid.
was something around 13 lakhs. And
18
yeah, 18 lakhs. And the value of the vehicle, after damage, it has shot up to something around 24 lakhs.
Yes, Lordship. So
So
they decided to go for a
Mm.
total loss.
Mm.
And at that point of time,
Mm.
they called for the salvage bid. Therefore, we went to the insurance ombudsman,
Mm.
and we have challenged that salvage bid. So we claim a higher amount, and that was given.
Okay, show me the initial policy and all. Let us go to the policy
Yes, Lordship.
and policy and terms and conditions there. Which page?
Insurance policy is at page 48. Page 48, Annexure 6 is the type copy.
Page 48.
Yes, Lordship, it is the type copy, and original lodging is at page 51.
Okay, what are the terms and conditions? You read the appropriate terms and conditions, which are the relevant terms and conditions for your case.
Lordship, here that the insurance company has given the IDV, fixed the IDV at 18 point.
What is IDV?
That is insurance declared value.
Insurance declared value. Okay.
Yes, Lordship.
IDV.
Yes, Lordship.
Insured.
Insured's
declared value.
18 lakhs 94,000. Oh, sorry. 18 lakhs, yes, 94,000.
Where is that?
Lordship, it is at page 49.
Page 49.
Yes, Lordship, total.
Yes, yes.
It was wrongly written as 1 0 was missing there. It should be 18 lakhs 94,000.
So how come 0 is missing?
Lordship, due to typographical mistake, that has.
Why typographical mistakes happen like this? I mean, amount.
Sorry, Lordship.
Then,
Lordship, the vehicle was shown to be total loss. They are ready to pay this. We are not agreeable to that.
how it is shown as total loss? What is the criteria? How it is done? What is the mechanism?
Lordship, there is that one consolidated affidavit I have filed.
See, I don't deal with insurance matters every day. So you'll have to make me understand how the mechanism works.
Lordship.
Correct. So you make me understand how the mechanism works. Then only I would be able to adjudicate the matter.
Lordship.
Please.
Lordship, I have filed one consolidated affidavit in WPC number 6677/2023.
Now, from this, I mean, from the policy, is there anything which is relevant?
No, Lordship, because that
Policy only you are showing me the price.
Yes.
This is insured's declared value.
Lordship.
Other than this, anything else that you want to show me?
Now, I don't want to show anything from there, but I want to show from the consolidated affidavit how the IDV is to be calculated as per the rules.
Okay, where is that?
Lordship, one consolidated
Other
petition, there is a consolidated affidavit.
petition, you have filed a consolidated affidavit. Okay, let's go there.
It is at page 94, Annexure A2.
Page 94.
Yes, Lordship, running page 94, Annexure A2.
I don't get my note. Annexure
A2.
A2
Yes, Lordship.
or A1?
A2, Lordship. I'll first come to the A2, then I'll come to A2. A1. It is India Motor Tariff.
One second. Yes, what is India Motor Tariff?
It is, Lordship, it is written there, the India Motor Tariff. The Tariff Advisory Committee, hereinafter called as the TAC, have laid down the rules, regulations, rate, advantages, terms, and conditions as contained herein for transactions of motor insurance in India in accordance with the provisions of the Part 2 of the Insurance Act 1938. Lordship, may kindly.
1 second. Yes.
Then, Lordship, in the next page, it is written the provisions of this tariff are binding on all concerned, and any branch of the tariff shall be any breach of the tariff shall be a breach of the provisions of the Insurance Act 1938. Now, Lordship, may kindly turn to the next page, that is page 18. The depreciation of the parts for the partial loss claim.
Page
18. or sorry, 96, next page.
Now, what is this document? Indian motor tariff. You have taken it from where?
Lordship,
Is it a type copy?
no, Lordship.
Hmm?
This I have downloaded from the website of the IRDA.
But only few pages you have given. 1, 2.
Lordship,
You have taken from one page, one
Lordship,
page. you
I have given
taken-
only the relevant portion. That is the applicability and the authority. That first 2 pages I have given, and the relevant portion where the how the IDV is to be calculated. That has been given in page 18. That relevant page I have given. That is GR9. If required, Lordship, I can give the full document.
Not okay. Right. What is the?
Lordship, it says the how the depreciation for the vehicle IDV should be calculated. Not age of the vehicle, not exceeding 6 months.
No, where you reading?
Page 96, running page 96 and internal page 18.
Yes, 96. Yes.
There is a chart given, table given.
Hmm.
Not exceeding 6 months.
No. Read from the beginning. Depreciation on parts of partial loss claims. Is it that? GR9.
Yes, Lordship.
Then follow.
The rate of depreciation shall be all rubber, nylon, plastic, such and such. These are not required because I am concerned with the depreciation of the vehicle. That is to be required for the calculation of the IDV.
Okay, the age of the vehicle, so and depreciation is given.
Yes, Lord.
Correct. Your vehicle is
My
aged.
vehicle comes within exceeding 5 years, but not exceeding 10 years.
So 40%.
40%.
40% depreciation.
Yes, Lordship.
Insurance.
Then, Lordship,
Hmm.
this has been reflected in the website of the insurance company also. They have also given. It is at
So
page
your
91.
vehicle is 5 years, but not exceeding 10 years.
Yes.
So you get 40% depreciation value. Correct.
So,
Now what has happened?
Lordship, in the insurance company,
Hmm.
they have also reflected this in their website, the IDV. The depreciation for the car and bike insurance.
Where
That is at
where?
page 91.
Huh?
Page 91.
Page 91.
Yes, Lordship.
Yes.
That is 3 to 4 years, 40%.
3 to 4 years, 40%.
Yes, Lordship.
But it is not there. 5 to 10 years is not there.
No, Lordship. That my vehicle, I have purchased the vehicle.
No, here, I mean, here they are not showing 5 to 10 years value, depreciation value. They are only showing 3 to 4 years.
Yes, Lordship.
So 3 to 4 years is 40%, but we do not know from this document whether it's 40% or not.
Lordship, it will be 40% because I have said it. My vehicle
But you
was
have said so, but you show me from the document. But you are saying this is IFCO Tokyo insurance company document, right?
Yes, Lordship.
So they have in their website they have given this 3 to 4 years 40%.
Yes,
But
Lordship.
after that they have not given anything.
Yes, Lordship.
Now you show me that like in their insurance also the insurance you are covered with that depreciation 5 to 10 years is 40%. You have shown me from the rule that I have seen. Rule
Yes.
means that guidelines or whatever it is. It is India motor tariff. What I do not know. This is what. This is only.
I have purchased the vehicle in the year 2018. So it will come under 3 to 4 years, not 5. 3 to 4 years. My vehicle.
Now you have said that you fall under 5 to 10 years.
Lordship, that was mistake. My mistake.
So if you keep on doing mistake like that, I mean,
No,
you have showed me that relevant provision saying that 5 to 10 years my depreciation will be. Now you are saying 4 years.
Yes, Lordship.
When did you buy the vehicle?
It was purchased in the year 2018.
2018.
Yes, Lordship. I have given the registration.
So you
certificate
met with an accident when?
in the year 2023.
23.
Yes, Lordship. On 6/5/23.
So you will come under come within 4 years.
Yes, Lordship.
Are you sure?
Yes, Lordship. I have given the RC also.
So yours will be you are saying that like 3 years to 4 years, so you'll come under 40% depreciation.
Yes, Lordship.
Yes, correct. Then
So thereafter, the insurance ombudsman has taken into consideration this aspect and they have enhanced the IDV to 22 lakhs and IDV was enhanced by 22 lakhs 64,400 and in the order they have enhanced the IDV to this.
where is
and
the order? Where is the order?
Lordship, the award that is given by the insurance ombudsman, that is at page the relevant portion is at page 73
73 of which document, which petition?
of the writ petition that I have filed, that is writ petition number 5764/2023.
Which page?
Lordship, it is at page 73. Yes, Lordship.
What
The respondent, I'm reading, respondent insurer is directed to settle the claim at adjusted IDV of rupees 22,64,400, less the balance OD premium on the IDV difference of rupees 3,75,000 and applicable policy fee. The salvage of the insured vehicle shall be disposed by the respondent insurer on with or without the RC basis at the option of the insured complainant. Payment shall be made as per the norms.
What is this OD premium?
OD premium, sir, OD premium.
It's called own damage premium.
Hmm?
It's called, he has asked me to look.
Hmm.
It's called own damage premium.
All damage.
Own
damage.
Own damage.
Own
When
damage.
it suffers a damage,
Hmm.
it also can also injure somebody. That's called third party damage. If it hurts, kills somebody.
It's an own damage.
The damage suffered by the vehicle is called own damage.
Hmm. So own damage premium on IDV.
Yes, sir.
Difference
Because-
is 3,75,000.
IDV was calculated less, so the premium was given lesser. So now as the IDV has been enhanced, so premium, the extra additional amount has to be paid against that premium that was enhanced. And thereafter, the award was passed.
Okay, Mr. Goswami, I mean, what is your problem with this?
What's it? I'm on a different area altogether. Lord.
Hmm.
He's filed this petition under Article 226.
Hmm.
I have come under Article 227.
Hmm.
My ground lordship is that the Honorable Ombudsman did not have the jurisdiction to try this case. So this complaint could not have been entertained by the Honorable Ombudsman as per Ombudsman Rules 2017. So it may take out Insurance Ombudsman Rules 2000.
No, now, which petition you will refer to? You will refer to the
Item number 12.
My petition, lordship.
yours is this thing,
My petition, lordship.
6677.
Yes, it is.
The insurance ombudsman.
Ombudsman. Have the book with me. Rule 14 says, lordship, the insurance ombudsman gets his jurisdiction from these rules. lordship.
Okay, rule 14.
Rule 14.
Yes.
Manner in which the complaint is to be made.
Yes.
It says, lordship, any person who has a grievance against an insurer may himself or through his legal heirs, nominee or assignee, make a complaint in writing to the insurance ombudsman. It's complaint in writing,
Hmm.
within whose territorial jurisdiction is the branch or office of the insurer complaint of complaint against or the residential address or place of residence of the complaint is located. The complaint shall be in writing, duly signed by the complainant or through his legal heirs, nominee assignee, and shall state clearly the name and address of the complainant. Number 3, lordship, no complaint to the insurance ombudsman shall lie. Number 8, unless the complainant makes a written representation to the insurer named in the complainant. It's called, lordship, not a claim intimation, it's a written representation. I'll come to that, lordship, it will become very clear. And either the insurer has rejected the complaint or the complainant has not received any reply within a period of 1 month after the insurer has received his representation. And the complainant is not satisfied with the reply given to him by the insurer. lordship.
So
Lordship, none of these
in your case, there was no representation file.
Lordship may come to my list of dates. Lordship, it will become very clear. how it has been fast tracked. It has been so fast tracked.
No, I mean, this, he has a, he has a, she has a policy, right?
Yes.
So she has a policy, and whether she claim for it, she claim for this probably.
Yes, Lordship. I Lordship may.
Okay,
I'll show the date, Lordship.
okay. A page,
That insurance company had acted, most company had given them the IDB. That's the
okay,
maximum they can give.
page.
Page, Lordship, is a list of dates in my petition, Lordship.
Yes.
Lordship may see how fast things have moved. On 6th, Lordship.
No, he doesn't have any, he doesn't have any complaint about that.
Lordship, see, the insurance ombudsman did not have a jurisdiction to come in at this stage.
No, correct. No, I got your point, but he doesn't have any objection about this thing, problem about, I mean,
Within month, Lordship, we have 7 lines, within a month.
okay, I mean, list of dates,
6/5 date of occurrence of the accident.
6/5 years.
6/5.
Mm.
On 10/5, he has given an MBA report.
Mm.
That means it is filled. On 15/5 only, which can be considered important because that's the day.
So respondent
we
number
have-
2, who is respondent number 2? Respondent petitioner, okay. Estimate of loss submitted by the petitioner,
Yes, Lord.
okay, then,
Along with intimation of claim. That is the date when it can be said that insurance company came to know about this 15/5.
15/5,
15/5.
Lord, yes.
See, within 15 days, no insurance company acts that fast. Meeting with the petitioner and the respondent number 2.
Okay. Correct, then.
Then on 19/6, the result of that communication meeting was communicated. 19/6. It was sent under post and it was duly received. I have enclosed the envelope also with this.
The communication of the value of the salvage.
Salvage as a process. Here I need to come in and explain a bit. What happened the moment it was decided, because the policy was for 18,94,000.
Correct,
They submitted an estimate for 90,90,000.
correct.
And my surveyor, he decided this vehicle, because repairing is a very costly,
Costly affair, yes, yes.
It's
The parts are more costly, yes.
more costly and it adds up to more than the total.
Correct. If you assemble the whole thing, then it will go much more than the value of the vehicle, yes.
What happened is, after this, then the survey assessed it as 23 lakhs.
Surveyor,
Assessed it as 23 lakhs.
23 lakhs.
So
Yeah, your surveyor,
My survey.
your surveyor, 23 lakhs.
His estimate was 1990, which is more than the IDB, insured declared value. Why it's called insured declared value also? He has the privilege of fixing the sum insured. I'll also come to the pages he has referred and show how the.
So he fixed it on 19 lakhs something.
It's called insured declared value. The
Correct.
terminal is insured declared. Earlier it
So
was
he
called sum
decided,
insured.
he decided to insure it on the value of 18 lakhs something.
Yes, sir. That is the word, the exact word is insured declared value.
Correct.
Earlier it used to be called insured estimated value. Now he's said this is your insured declared value, take it. Or you want to go for a different sum insured, you have a right to do so. And his pages he has explained.
The only thing is that like, he'll have to pay more premium.
More premium. That's explained. What is very clearly explained.
Correct,
He
got
had the
it.
option, he did not do it.
Correct.
So Lordship, within 1 month, Lordship, 19/6, 30th May, the meeting was fixed. 19/6, they have completed the entire process. In the meantime, Lordship, if it is decided it's a total loss, insurance company has to think of disposal. Because the moment, the more it stays in the garage or lying outside there, it will gather rust, oxidation will take place.
So
and
basically,
then it
you sell it on this thing.
will auction.
Huh?
Auction.
You auction it, right?
Auction doesn't take place in auction for completing the auction. There is a lot of process to be involved. But what they do is immediately they need to ascertain the value. That's why they call for bids. It's not selling in auction. They only wanted to know what is the value of this vehicle.
It's sold as a scrap, isn't it?
It's sold as a scrap and sometimes it's given back to the yeah. If you want to retain it, you can.
You'll have to pay some money. The value will be
We'll deduct the value from that deal.
correct. So he
For all purposes, it is required to know the value. What is the value in the market? Which is why lots of bids were called from various known auction buyers, sell by buyer. And only then thereafter they will communicate, look, this is your area. We have decided the total loss in reference to the meeting that 35. And they will say, this is this. From that letter, they electively made out a meaning that we have sold it. How can it be sold? It was lying in a garage. We have to take her permission. The forms have to be sent. No one will take away a vehicle without written or heard the signature of the owner. That's impossible. No one can sell a vehicle like that. It will not legally. And it was lying in the authorized garage, the workshop. And why will they part with the vehicle without the owner's? Lordship, that is something. And 27/6, Lordship, within 7 days. 27/6 complaint filed before the ombudsman. Where is the complaint in representation in writing law? It's a precondition. There has to see is either dissatisfied with the settlement or repudiation or anything that she had written, she had not received the reply within 1 month or not satisfied with the reply. These are the 4 conditions. Only then she can approach that. There must be a written representation, which is not there in this case. And in the representation, either she is satisfied, not satisfied, then she goes to ombudsman. Without fulfilling that criteria, insurance ombudsman or ombudsman lordship has taken over the job of the insurance company of settling the claim. We have to just communicate that this is our year. After that, she ought to have come with some reason. Look here, we are not satisfied. This, that. Then only she could have got.
So your main ground is that like there was no representation, and since there is no representation from his side, as per the statute, the ombudsman doesn't have any jurisdiction.
Complaints and lie. Complaints and lie unless.
So that is the only point, or do you have any other points?
I have other points also.
Other points?
As regards,
You are basically challenging this. I mean, under 227,
one point of
227, you are challenging this only that.
I've also added some more points because it's a decision of the Supreme Court. Also, I have a list of exceptions. No court in India can rewrite a contract. Insurance contract is taken a separate kind of a contract, a little different from the other contracts. But any contract, once a contract is made, no court in India can rewrite a contract. Plus, if a proposal is made, I'm satisfied to give all these suggestions. May I present a lot of the summation of my suggestions? I'll rely on this. And this side.
These citations are on the point of
that
rewriting of the contract,
rewriting of
or on the jurisdiction of the ombudsman.
No, this is only on rewriting of a contract.
You have any cases on jurisdiction of the ombudsman?
No, the book.
The point that you have raised.
Relying on the provisions of the book.
That I understand, but like whether there is any judicial pronouncement on that.
I will look for it. I'm not very sensitive. But there's some more thing. Once a contract is concluded, once the insured here has got the policy.
This is the list of cases. List with the small notes. And these are the case laws.
That I'm relying on.
And these are the case laws, right?
These are case laws.
No, whatever you have referred here, these are here.
Are all the case laws.
Correct. Yes. Now you want to point. You want to show me any particular case? You want to show any particular case? Now, do you want to show any particular case?
The first is lots of Devkar exports. The nature of insurance contract, Devkar exports.
Yes.
Para 13.
Para 13, yes.
A policy of insurance is a contract based on an offer.
Proposal and acceptance, yes.
The applicant made a proposal. The insured accepted a proposal with a modification. Therefore, it was a counter proposal. The applicant had 3 choices. The first was to refuse the counter proposal, in which event there would have been no contract. The second was to accept either expressly or impliedly the counter proposal of the respondent. That is the respondent's acceptance with modification, which would result in a concluded contract in terms of the counter proposal. The third was to make a counter proposal to the counter proposal of the respondent, in which even there would have been no concluded contract unless the respondent agreed to such counter proposal.
No, that is fine. I mean, these are settled law of contract.
Next line is the applicant definitely did not have the force of choice of propounding a concluded contract with a modification neither proposed nor agreed to by either party. He could not now wistfully think that his sum insured ought to have been this, not that. If he was unhappy, he could have objected to it.
No, do you have any problem in that? I mean, as far as the contract is concerned, he doesn't have any problem. What is your problem? Your problem was only thing is that you have received more money. You have got more award than whatever is declared value.
No, Lordship, what they have done, that the reason given that the
No,
There is a procedure.
now it boils down to one thing only. You have not filed any representation. And once you have not filed any representation, and that has not been addressed by the insurance company, you could not have directly gone to the ombudsman. That is the
Lordship,
point. And what is the answer in that?
Lordship may kindly look to the letter dated 19/6/2023. That is annexed as page 31 of the writ petition filed by the respondents. That is writ petition number
Page
6677. Lordship, it is at page 31.
Page 31.
Yes, Lordship.
Yes.
This is by registered post.
Correct.
But the receipt annexed is a blue dirt receipt, and that I have not received at any point of time. I have specifically stated this is my stand. Lordship may kindly look into this letter in the one.
No, what you
There are certain points given in the bullet number.
This is a registered post, right?
Lordship, but no receipt has been annexed, and this letter was never delivered to me. I have repeatedly communicated them through emails and no communication. And in this letter, Lordship, the bullet point number 1, 2, 3, 4, 5. The salvage buyer was asked to lift the vehicle since the quote was valid till 18/6/2023. Before issuing this letter, the salvage buyer was asked to lift the vehicle. So that
was not communicated to you. That's what you're saying.
This was not communicated, and before issuing this letter, the salvage buyer was asked to lift the vehicle. That is why I approached the ombudsman directly, because without my consent, they have called for the salvage buyer, and on 18/6/2023, that is before the first communication made with me, the salvage buyer was asked to lift the vehicle. So this was an afterthought letter was issued, and that was not communicated at any point of time to me. I have not received that letter. That stand I have taken. So that is why I was compelled to, because when I came to know that the salvage buyer has come to leave the vehicle, then I have immediately approached the insurance ombudsman. And my complaint was on 28/6/2023. When I came to know that so they decided to go for total loss. They asked the salvage buyer without any.
But you were not aware of total loss?
Lordship?
You were not aware of total loss?
Lordship?
You were not aware of total loss?
Total loss.
That it will go for total loss because your vehicle was totally gone, right?
Lordship.
It was full damage. It can't be done anything.
So total loss.
And if you repair, it will cost you more than 24 lakhs.
Lordship, they were proposing the total loss, and I was proposing for the repair of the vehicle. That dispute was there. In between, without informing me, they called for the salvage bid. They asked for the leave to leave the vehicle, and they sent a letter before the after the last date.
Okay, this was sent on when? 19/6/2023.
Yes, was stated to be sent on 19/6, but that was not communicated to me at any point of time. And the receipt enclosed is a blue dirt receipt. This is courier receipt. And I have specifically stated that.
And 35/2023 meeting, is there any minutes of that?
Lordship, in that meeting, there was dispute.
Is there any minutes of that?
No, Lordship. That was a verbal meeting.
Nothing was
what
there.
I have been informed is that there was a verbal meeting.
Is there any email communication after that?
Lordship, there may be email communication that I have not annexed on that day. Because the email that I have annexed, it's are subsequent. These are of the month of July. But I've been informed that there are emails in between 35.
Mr. Goswami, is there any document showing this has been delivered to them? This communication?
This communication, Lordship.
19/6/2023 communication.
Lordship goes through page 52, his complaint to the insurance company. That almost makes it clear.
Where,
He was
please?
in receipt of this information.
Okay, where?
Page 52 of his Lordship.
Page 52.
Of his petition, Lordship.
Lordship, on 20.
One second. Page 52.
52. Annexes 7 of his petition.
Page 52, yes. Yes.
From para 2, Lordship.
Para 2, yes,
After
yes.
the accident, I submitted an estimate from Toyota which amounted to rupees 20 lakhs.
No, para, yes, para 3, yes.
Para 3, Lordship. Which amounted to approximately rupees 20 lakhs. It's actually the insurance company presented me with two options. The first was to accept only 50% compensation from their end for repairs. This I denied, not substantiated. While the second was to declare my vehicle as a total loss. That he has admitted. That there was an option to declare it as a total loss.
And the second was to declare my vehicle as total
Total
loss, where I
When
will
I
receive
receive the
any
IDV
value.
value of my vehicle and they recover their money by selling my vehicle on auction. Admitted position loss.
Lordship.
She was told
Yes.
this is her complaint, not mine, Lordship.
Hmm.
But the complaint itself shows
Then
that
keep on
she
reading,
was
keep on reading.
aware of the position that vehicle will be treated as a total loss and it will be sold in auction. We did not sell it. But every insurance, what they do is immediately ascertain the value. The first was to ascertain, to know what is the value, how much they can deduct from the total loss, if the insured wants to retain it, or how much this can sell it for. That's important for them to know the immediate. But this question of selling the vehicle was known to her.
But what about the selling of the vehicle?
Vehicle was not sold, Lordship. It was maybe later was there's something. It was that line was out of context, Lordship. But is that intention also that we have called for quotation? This is the value. How can a vehicle be sold, Lordship? It's something practical. It cannot be sold without her consent. Taking it from the garage, RC, and all these documents transfer has to be there. DTO has to be informed.
No, you don't sell the vehicle, na? You sell the scrap. You sell it as a scrap.
Even that product, it's not. It's still there, Lordship. They know about it. It's still there. Plus, I'll come to the next page, next para. I requested some time to consider the options. It's not that she was taken by surprise.
Where?
Same paragraph.
I requested some time to consider the
Consider
options.
Hoping to make an informed decision.
Correct.
To my dismay, I received a call almost 2 days later. We don't, I don't know whether this is substantiated. I don't admit it. Where I had informed that insurance company had auctioned my vehicle without my consent. This is not without any substance. No one had informed that it was auctioned without her consent. That auctions bids were called for just to know the value. What is the value of this scrap? The reason cited was that they received a favorable price of around 16 to 17 lakhs. Fully aware of the fact, and yet they do not complain to the insurance company that I reject your offer. I reject the settlement. That representation was required to be there. When she was aware of all this, that representation, that is the requirement of the Rule 14 laws. There must be a representation. Then what the reply she receives from the A. If it's a case of repudiation, then also they can come to ombudsman. If it's a case of dissatisfactory reply or no reply, then also these are reasons how they can come to the insurance ombudsman. That representation, we were taken by surprise to receive this ombudsman seat because normally people complain. They give a representation. Then we can go for further negotiation.
Now, see, I mean, now the thing boils down to one thing is that you have not filed a representation admittedly.
Yes, Lordship. That we have not filed.
So whether you can do it
Lordship,
without filing a representation, you show me a case law where you can do it. And without filing a representation to the insurance company, you can directly approach the ombudsman and the insurance ombudsman has the jurisdiction to decide your case. You show me a case law, then we'll think about this. You have a case law?
readily, I don't have. I pray for 1 day time to submit.
So with then you bring that case law.
Yes,
Bring that judicial pronouncement wherein it has been stated that if in urgency there are certain compelling situations, then the party can directly approach the ombudsman for certain reliefs without filing this representation under Rule 14.
Or
so if you have anything, you give me. Yeah, because that is the point. I think there is no other point.
Yes.
If you succeed in that, showing that like ombudsman, they have filed a case only on the basis that the ombudsman doesn't have the jurisdiction, and you are saying that like because the compelling situation was there, my vehicle was sold in auction, so I had to go to. You had to go to this ombudsman, and ombudsman has rightly passed the order.
There are some other points. Also.
But mainly that, I mean, I don't think that there are
I'll
other issues.
I'll deal with that particular point also.
Lordship, this may be kept as a part heard on some of
No, not part hard, not part hard. You bring in, we'll hear it. We'll just post it on.
Can it be heard before Bihu vacation?
1st of April.
Yes.
1st of April, you bring it. Heard, Mr.
SN Tamuli.
SN?
Tamuli.
SN
TMA.
Tamuli for the SN Tamuli, this petition.
I'm R Goswami.
5764, SN Tamuli for the petitioner, and Mr. R Goswami for the insurance. Respondent number 2 and 3. R Goswami for respondent number 2 and 3, and S Datta for respondent number 1 in this petition. And other petition, Mr. Goswami will be the petitioner. Okay. Goswami will be the petitioner, and he will be he's a pro forma or what? In your petition?
No,
He is not party.
No, Lordship, in my read petition.
No, I understood. No, in your read petition, whether he's a party.
Yes.
He is respondent number what?
No,
3.
he is not a party. Insurance
Insurance ombudsman is respondent number in my case, and
Respondent number 1.
No, he is for IRDA. No, he is not a party. In read petition filed by the insurance company, he is not a party because he is for Insurance Regulatory Development Authority.
Correct.
ombudsman
But whether you should have made him party or not? Because you are challenging his
that particular order, insurance ombudsman and
you are challenging his jurisdiction. Anyways, I mean, we'll look into that. Then he's record respondent. Huh? These 2 petitions you check and let the matter be listed. Let the matter be listed on 1st of April.
And Lordship, that jurisdiction point was never raised before the ombudsman. Jurisdiction point was not raised before the ombudsman during the contest.
Okay.
Much.
Yeah, Lordship, in this matter, Lordship, I'm sorry, Lordship, I'm praying for accommodation only for the day, Lordship. There is some difficulty, Lordship. Accommodation only for the day.
Okay. You are Mr.
G.J. Sharma, Lordship.
On the prayer of Mr. G.J. Sharma, the Lordate Council appearing for the petitioner. Let the matter be fixed after the verification. After the verification. You are? And she doesn't have any objection to that. Right.
Interim order may be continued till then.
Interim order so passed earlier, so we'll continue with the next state of list.
Deeply obliged.
Is mine.
14 and 15.
Panchayat এখন করছে
Yes.
রেকর্ড কিবা my lord, we'll just hear it. Then if your lordship feel record is necessary, then your lordship will take a call. Then your lordship will take a call.
The record was called for what?
Uneasily.
Record was called for?
But if your lordship will kindly see the last order which was passed by this court. Yes.
The last order to nothing is there.
Last was an adjournment shot, I think.
Kindly list the matters so and so for final disposal. That was passed on 27/2.
27.
Okay, pleadings are complete.
Yes, yes, all is complete.
Pleadings are complete.
Yes,
Oh,
it's
Mr.
a
Kumar?
matter regarding my lord.
No, it is not. There is no order in the, on this.
Well, I can start the case. No, I will let me start the case. Lordship feels the record is necessary can be called. My lord, I am for the
No, Mr. Das, again, I mean, if records are very much necessary, then I hear the matter, then again, I mean, the time will be wasted. So you decide whether records will be necessary or not. I'm not sure because I have just, I mean, browsed through the matter because I have not gone to the depth.
because what I feel, my lord, that record may not be necessary in this case for one reason. It is a matter in a Panchayat Act for the first time. The law of anti-defection law has been laid down, statute, under this statute. So this was not there earlier. Anti-defection was brought into the statute. Kindly see that. Then therefore, Lordship, this is what we are projecting our case.
Panchayat Act on Divide Panchayat Act.
Please see the Assam Panchayat Act.
So this concept has been brought in, whip
Yes.
and anti-defection and all these things.
My lord, I'll just tell. There was this is in respect of Jila Parishad. Election of Jila Parishad, it was notified. Now thereafter, my lord, there were 3 belongs to Congress and 1 was independent from different constituency. Your lordship, the facts. And ultimately, I own from 1 constituency and 2 other Congress own from 1. And my learned friend is from another constituency, another Congress. Now 3% own from the Congress, 1 from independent. The next point is that this selects the election of the president. Now, election of the president, there was a party whip on 2/8/2025, 2/8/2025, no? 25 a party whip.
All three
So all
Congress
three,
candidates.
now all 3 Congress candidates, 1 was an independent. There was a party whip from District Congress Committee
To the Congress
saying that
candidates,
this
yes.
is one, we are selecting this petitioner as a president. So then so direction is given by the party whip. So this is what direction you have to elect. Now this has been notified to all the Congress members. Thereafter, on 4/8/2025, the 2 Congress, the party, they informed Deputy Commissioner, look here, there is a party whip which has been given. So this is a direction of party whip. This is our candidate for the post of president. Now 7/8/2025, my lord, it was called before the meeting was called for selection of the president and the vice president. And in that case, my lord, what has happened? The independent candidate supported the one of the Congress party and supported no, he should be elected as one of the president. Then this what happened, and ultimately there was 2/2. Now 2/2, then in the deputy commissioner said that it will be a toss. Ultimate toss, my learned friend's client owned as a president, and thereafter he, the independent, owned as a vice president. Correct? This was put to challenge by us. Immediately on that day itself, we have written to deputy commissioner that what you have done it. We have informed to you. This is amount to anti-defection law. This is under a statute. This is what our the district Congress committee has already taken a president has taken a decision. You have violated the statute. He said there is no question of violation of the statute. I have not seen any provision or procedure which has been laid down that it cannot be one of the members cannot vote another member. This is what he said. So ultimately he was elected and he became the president. And this is put to challenge by us. And our whole case is that this is a violation under 111 of the Assam Panchayat Act.
So this is your case, and what
This
about
is
the
our
other one?
case.
Other one? Other one filed by?
But he is the vice president.
Oh, vice president.
Yes. Same.
Okay. Oh, you have also filed at the same, but you were an independent candidate.
No, he was the vice
Oh, you were the
Congress
you were the
party
Congress.
was
one.
nominated for the vice president.
Yes.
The independent supported you.
No, he is not. He is with us. He is
He
with
is
us.
with you. Okay.
Yes.
Okay. Other side is this.
Other
side.
side, my learned friend is there.
All this has been recorded in the
No.
resolution and record.
No, kindly see.
Record is here.
My lord,
Minute of sale.
I think
Subscription.
it is there.
No, what resolution? No, no, this is not disputing that the party whip was there. And
We will not be applicable to this, panchayat election. Will not not submit on the merit, your lordship call for a record and fix it immediately.
No, record is already there annexed. There's no further record is required. Well, let this deputy commissioner decide the issue.
There is no independent candidate, please become Congress.
No,
It's not a defection
that
from
authority
one
will take a call. Lordship will have the statute for a moment, my lord. Your lordship should kindly come to section, page 121, my lord. Page, no, 120.
Page number 1.
Page 121. And section 111, subsection 3, IC.
111.
My lord, in the book, page 121, my lord. Subsection 3 of section 111.
This is the same book.
Yeah, oh, my lord, no, I am having
Oh,
some.
it is
And lordship will have section 111.
111.
Section 111, subsection 3.
Yes.
Same book.
In case of a Jila Parishad, has your lordship got it?
Yes,
Yes. Yes. In case of Jila Parishad, member or members of a political party shall be disqualified if he or she, kindly come to see me, Lord, votes or abstains from voting in contrary to the respective political party in election of the president, vice president, members of a standing committee, or in a voting of no confidence motion against any of them. Now, 2, the district commissioner shall have absolute power in deciding the cases pertaining to disqualification of member on the ground of defection. So this is the law, my lord. So, my lord, and page 49 of our petition, my lord.
Item number 15, my lord.
Item number 15. Please come to page 48, my lord, the last subpara.
Page
48, my lord.
48.
Yes. I'll have your lordship's kind attention to the last subpara, sentence starting with since.
Yes.
Since 2 candidates were nominated, voting was conducted to elect the vice president. Both the candidates secured an equal number of votes in 2 votes each, that is 2 votes. Consequently, the selection was decided by a toss of coin. Prior to the toss, district commissioner assigned head to the Wahidur Rahman and tail to Nur Yasmin Sheikh. With the consent of both the candidates, the district commissioner conducted the toss and declared Wahidur Rahman as the winner. It is pertinent to mention that during the process of proposing the name of election of president, when name of Mrs. Tanzina Khan and Mrs. Mijuna Begum were put forward for the said post, Nur Yasmin Sheikh raised an objection questioning whether 2 candidates from the same political party could be nominated. She further referred to the provision relating to party whip and anti-defection. In reply, the district commissioner clarified that neither the Assam Panchayat Act nor the Assam Panchayat Rule contain any provision prohibiting nomination of more than 1 candidate from the same political party. He further stated there is no reference to any party whip in either of these annexments, citing section 1113 of the Act in relation to anti-defection. The district commissioner further explained that no provision under the said Act applies to disqualification of a candidate belonging to the political party in the context. So this is the infirmity, my lord. And this is the only record, my lord. So, my lord, these orders should be interfered with and matters should be remanded to the deputy commissioner, my lord, to take a call having regard to the statutory provisions, my lord.
But if they have concluded on the merit of the case, then we'll bring out the record.
No, record is not required. I mean, see,
They have.
is there any other issues other than this?
My lord, first.
See, is there any other issue?
My lord, I will open my, when provided they have concluded that, then I will address your lordship. Because they-
Yes, I have a right of reply.
You have concluded, then I will start my argument.
That's the case. Where you projected that there is a provision on the Panchayat Act.
Yes.
So this was the basically,
applied.
basically this was not taken into account by them.
Yes. It was notified to deputy commissioner.
No, he
And according to the deputy commissioner, there is no provision.
no provision.
My lord, deputy commissioner, he's an IS officer, he doesn't know the provision. It was forwarded to him, this is what.
So this is the only issue there is.
Absolutely, that's the case of the interpretation of the law. This is only one side of the point.
Okay, I mean, you argue upon your point.
Proceed. I'm agreeing the party which is issued a way.
This is.
So that is my
Respondents about in
My going was violated.
which case? Both respondents. So you are appealing for Congress party, and like your whip was violated by them.
And my lord, one more thing, my lord. If your lordship would kindly come to page number 70, my lord. This is the affidavit in opposition filed by respondent number 4.
Page number 70.
Page 70, my lord. Part of the para 12 of the affidavit filed by the deputy commissioner.
No, which petition? Yeah, I mean,
My lord,
15,
4962.
15 now.
Yes,
15.
please have page 70. Para 12.
Yes.
So, my lords, may kindly have para 10 also, my lord. Please come to the last two sentences.
So this is affidavit by someone, Rahul Kumar
Deputy,
Gupta.
Deputy Commissioner. my lord.
Deputy Commissioner.
Yes.
Who is appearing for Deputy Commissioner?
Government.
Government, my lord.
Government. Who is appearing? Government. Okay, fine.
Yes.
Para 10.
Para 10, my lord, last sub-para, it is pertinent to mention that any action taken in the first meeting of the Jilla Parishad held on 7/8/25 was completely in accordance with the relevant provisions of the Assam Panchayat Act and the Assam Panchayat Rule as amended. As regards the petition submitted by the petitioners in respect of disqualification of respondent number 5, on the ground of defection, it may be noted that matter is under process, scrutiny and consideration as per the Assam Panchayat Act, section so and so. That as regards the para 12, that as regards the statement made in para 18 of the writ petition, deponent begs to state that respondent number 4 has absolute power in deciding the cases pertaining to disqualification of member on the ground of disqualification as laid down in section 11132 of the Act. The matter is under scrutiny and examination and will be disposed of in accordance with the provisions of law as per order to be given by the Honorable High Court. So this is this, and now once your lordship issues a direction, Deputy Commissioner will decide. That is their stand. So it is under scrutiny.
It's a very short and narrow campus. You don't have to go other.
Mr. Kumar will send it back. Let them decide. Let them decide.
This is their interpretation of the law.
No, I mean, there is a stand of the government. I'm not saying about anybody's. I'm not hearing their stand. I'm hearing the government stand. And government is saying that it will be decided as per the process.
That has already.
Okay, no. You submit your thing. No, you conclude. You submit it. No. Prima facie, whatever has been seen.
Everything sometimes
You are correct in that. So you argue your case. I will take which petition?
Your Lordship will take up WBC number 4962 of 2025.
Okay.
Noor Yasmin.
Yes. This has been filed by you.
So they have
They have filed.
Yeah.
We have filed.
Correct. They were both filed by them. Yes.
I am for the respondent number.
Correct. Yes.
In both the matters.
Yes.
Now your Lordship will see.
And your name is Tanjina.
Continue.
Yes.
Now your Lordship will see here there are four persons. The person who is sought to be branded as an independent is no longer a branded as an independent. Can't be branded as independent because he had joined the election after his election as an independent. He has joined the Congress. So these are all Congress. It is not a defection from the Congress to BJP or BJP.
He joined Congress when?
After his election.
After his election.
17/5/2025. So all of them are Congress. So the first concept of defection is that suppose a person defects from, suppose I'm a Congress, I vote against the BJP, then you can brand me as saying that I have defected to the other party or changed the party. There is no change of allegations of party. The whole concept of this disqualification on ground of defection, it arises from the 10th schedule of the Constitution. Your Lordship, for the time being, will kindly look at the 10th schedule of the Constitution. The
the ground of the disqualification on the ground of defection and the difference between the Panchayat Act. That will be necessary. Your Lordship will kindly look into the Constitution, the 10th Schedule 2. Because this 10th schedule is applicable to the state legislature and the parliament, not to the Panchayat.
No. I'm, see, there is a clear amendment to that.
Yes.
So like, are you challenging that over?
No, your Lordship will look into the language. Because some of the Panchayat Act, I will take your Lordships to the Tripura, Karnataka, Maharashtra and all, where the procedure is given what will be the consequences of the defection and all. Now your Lordship will see that disqualification on the ground of defection, the wordings of a particular constitution. Subject to the provisions of paragraph 4 and 5. A member of a house belonging to any political party shall be disqualified for being a member of the house. Two, your Lordship got it. Number one, if he has voluntarily given up his membership of some political party, which is same as the Panchayat Act, and I have not given voluntarily, this will not applicable to me. Number B, if he votes or abstains from voting in such house, contrary to any direction issued by the political party to which he belongs, or by any person or authority authorized by it in his behalf. Now, here your Lordship will find my learned senior HRS Sodari appears for the District Congress Committee. There is nothing on the record to show that the District Committee has been authorized by the Congress Party to issue the whip.
Okay.
To any direction issued by the political party to which he belongs or by any person or authority authorized by it in this behalf. First, they have to show that they have the, under their own bylaws and regulations, they have the authority to issue the whip. Without obtaining in either case the prior permission of such political party, these wordings are missing in the Panchayat Act.
Your Lordship's permission, can I think, please?
Yes.
Yes.
Without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or the clear-cut procedure is given. What will be the procedure for defection, which is absent in the present 11C. Now your Lordship will see the provisions of the Panchayat Act, which will be relevant for the purpose of this act. First, your Lordship will see Section 70 of the Assam Panchayat Act 1994. Here, since it is the Jila Parishad, your Lordship will see Section 70.
Yes.
Election of president and vice president of Jila Parishad. When the Jila Parishad is constituted under Section 64, the Deputy Commissioner shall call a meeting of the Jila Parishad, which shall be called the first meeting of the Jila Parishad for the election of the president and a vice president by the form amongst the members directly elected under Section 65(1)(1). Next, the election of the president or the vice president of the Jila Parishad and filling up of vacancies in the state office and the determination of dispute relating to such election shall be in accordance with such rules as may be prescribed by the state government or state election commission. If it was a dispute prior to the filing of the prior to the declaration of the result or to the election petition, then an election petition will lie. But here, since it is the dispute resulting after the election, the deputy commissioner may have the power. Now your Lordship will look into the next section.
71.
No. 45.
45
Yes. Of the rules.
of the rules.
Assam Panchayat Constitution Rules 1995. They say that there was equality of vote. And the deputy commissioner has shown that now your Lordship will say 45 of the rule.
Correct.
If after the counting of votes it appears that two candidates of whom only one is to be declared elected having required equal number of votes, the district commissioner or the officer as authorized by the district commissioner as the case may be, or any officer authorized by him in his behalf shall decide which of the two shall be declared elected by tossing up a coin in presence of such candidate. These candidates shall be assigned one side of the coin by him or by the officer such before the toss. The candidate whose side appears visible at the top of the coin after it has fallen flat on any plain ground or table shall be declared elected. Then your
Lordship's kind permission, can I
Yes,
take?
sure.
Yes, my friend is.
No,
then your lordship will know.
but this is fine. Toss and all, there is no issue.
Your lordship will see all this is by secret ballot. How they have presumed that I have not casted the vote? How they know to whom I have casted the vote? Because if your lordship looks into the rule 50 of the election of the president and vice president of the Jilla Parishad, I have not disclosed anyone to whom I have voted. This is all by secret ballot. So in a case of secret ballot, this whip will not be applicable.
No, Anita, the only thing is that they said that they have 3 members.
Who?
No, 4 members, the 3 are from Congress, they say.
Fourth one is also Congress.
The 4th one is after joining, after this thing.
No, on the day when the vote was casted, it was a Congress. So he will also, if there is any power to issue whip, then he will be also bound by it.
When did he join? He joined post-election or before election?
Before election.
Huh?
Before election.
After the election.
Not after the Panchayat election, but before the voting.
He contested an
Independent candidate, but in the time of this voting process for the election of the president and vice president, he is a Congress candidate.
Then how can it be like if
He has joined Congress, he has become Congress. He has no, after that, after joining Congress, he has no independent character. Independent character was prior to declaration of the result.
After declaration, he has become Congress.
Yes.
After declaration.
Yes. So he is 4 members. And it is not a case where Congress has voted to it. Because they have to show the power of the whip. There is nothing on record to show that they have the power to issue whip in a panchayat. The Congress, there are internal rules, or just like the article of association of a company, you must have the power to issue a whip. You simply cannot issue a whip in a secret ballot. And how do they know that I have not voted for this particular candidate's ballot? I have not disclosed. This right of disclosure is there in the Act. I'll take your lordship to section 50 of, Rule 50 of the Assam Panchayat Constitution Rules 1995. It's all secret, my lord. The Panchayat Act contemplates secret voting and not like open voting in the Rajya Sabha election, where they have to show to the party nominee that, look, I have voted this. And if you do that, then it will anti-defection law will be applicable. Unlike the Rajya Sabha procedure or the presidential election, where indirect elections are held, there this concept will come. But here
let us see 111, section 111.
Yes.
Again.
Your lordship will see. Yes, 111 PC. First 2 will not be applicable, my lord.
Yes.
Now your C will see. Votes or abstains were voting in contrary to. This is important. In contrary to.
No, say let's go from number 1.
Yes.
In case of
Jilla Parishad, members of a political party shall be disqualified if he or she, number A, voluntarily gives up the membership of a political party after the election result, which is not there. This will not be applicable in case of the independent candidate. B, changes the party affiliation with less than 50% of members of each or her political party. That means if you have more than 50, you can change the political affiliation.
correct.
Your lordship will rise for 2 minutes.
Yes, I'll just come back in 5 minutes.
Grade 11 P.
PC, let's see, read.
Votes or abstains from voting. There is no difficulty in understanding this. Then the next phrase.
Votes or abstains from voting in contrary to the respective political party.
The next phrase.
One second.
Contrary to the respective political party. That is the phrase.
Contrary to the respective political party.
That means it refers
So
to
contrary to respective political party means.
That means if it prohibits
No,
cross voting.
contrary means what?
contrary to the respective political
me-
parties, I cannot vote for BJP
Correct.
or AGP. Here, this is a question.
No, you said that there is,
This is the
no, you argued that there is no whip, power of whip.
That is first point.
Correct. So contrary means what?
Contrary to the respective political parties, it means that it prohibits cross voting, not internal voting between the parties.
Correct. Correct.
Here it is a question of internal voting between the parties. That is what I would submit. That is one point. But to know that who has voted for whom, that is by secret. That nobody knows.
No, the thing is that now, whether there is a whip or no whip.
No, first your lordship
So
has to
there is,
look-
whether there is a whip or no whip, if you are affiliated to a party, you are not supposed to vote to a party who is in your opposition.
Yes.
Correct. So that is the thing that disqualifies you.
Yes.
So question of like giving power of whip or no power of whip doesn't matter here.
Yes, if your lordship looks from that angle.
Correct. Correct.
Suppose if your lordship looks at that, yes, I have issued a whip to whom to vote for, president or vice president, whether that power is there or not. The Panchayat Act, as the learned, as Deputy Commissioner has said, that the Panchayat Act doesn't contemplate of a whip because everything is by secret ballot, as per 50 of the rules.
No, that is true. It will be secret ballot only.
Yes.
But the only thing is that a power of whip is there or not.
No.
But if the power is there or not there, doesn't matter. Yeah.
No. First, they have to issue the whether I have complied with the whip or not. That material is not before your lordship. Now, if there is a power of whip, say for example, both ways we will look into. If there is a power of issuing whip, then who is the competent authority to issue the whip? Here, my learned seniors HRS Chaudhary's response number 7 is the district committee, not the state committee. Say for in the assembly election, if you want to nominate the national party wants to nominate a candidate, then the Delhi has to issue that form A, and the local president will countersign it, authorizing him, and his signature and authority will be there. But in case of say AGP, he doesn't. It's not a
No,
national
correct.
party, it's a president.
That is understood.
So here they have not indicated any bylaws, any internal rule of the Congress party.
But a question comes whether he should be disqualified or not.
Yes.
Whether by a whip or not by a whip.
Yes. That is the only question. And your lordship will see this contrary to the respective political party. If we understand this simple language, it is only applicable in cross voting in favor of rival political parties. Not internal choice where all the candidates belong to one party.
Now this 3-2 says that district commissioner has the power.
Yeah, district commissioner and your lordship will see. When the
No, so so DC has the power, statutory power has been given to it.
and he has accepted.
So why should the court decide on this matter?
DC has already decided. And
No, now they have taken a different stand. They have taken a stand on their affidavit.
No, what your lordship will see.
See, now they have taken a stand on their affidavit, saying that like this, they are going to decide on this. The process is on.
My lord, affidavit will not change the original.
It will not change. It will not change, but there is an admission.
No.
That there may be certain thing wrong, so they will decide on this, and there is a statutory power given to that authority.
That power has already been exercised. Now in the affidavit, maybe I don't know for what they have for what. Your lordship will kindly see 71, page 71 of their affidavit.
Page 71 of
Their affidavit. Page 71 is the serial page, my lord.
yes, 71.
Your lordship will see. If they had filed again, one point your lordship will look here. If they had filed their objection before coming of the point, then also it would have been different. Here the objection was filed when they lost in the toss. Now it's a case of shock. Once they have subjected themselves to the tossing, and when the toss was not in their favor, now they have raised a grievance before the Deputy Commissioner.
Yes, 71. What is that you want to show?
Yes. It is an established fact, the fact paragraph.
Yes.
It is an established fact in accordance with the provision of Rule 54 of the Assam Panchayat Constitution Rule 1995 that only the directly elected members can propose and second the names of persons from among themselves as under subsection 1 of section 70 of the Act for election of a president and vice president of Jilla Pariషad. There is no provision of nomination of names by any office bearer of political party for the first meeting of Jilla Pariಷad to be considered as the matter of political party which does not arise. Then your lordship will see 73. Where?
Yes.
73. In the instant case, the petitioner referred to section 3(1)(c) for disqualification of respondent number 5 on the ground of defection. It may be noted that both the candidates proposed for election of president belong to the same political party. It may also be noted that though the respondent number 6, Sri Wahidur Rahman, contested and won as an independent candidate, subsequently he informed that he had joined in Indian National Congress INC party. It is further pertinent to note that there is no provision in the Assam Panchayat Act 1994 as amended and the Assam Panchayat Constitution Rule 1995 as amended to detect or identify the Jilla Pariಷad members or members for disqualification for the act as laid down in section 111(3) IC. Then you'll also see the page 74, paragraph number 9.
74, paragraph number 9. Page 74.
Yes.
You are party to that.
It is specifically denied that the respondent number 4 has not submitted a list of to State Election Commission indicating the name of respondent number 6 elected as Vice President of Jilla Pariಷad. The respondent number 4 has duly intimated the State Election Commission indicating the names of President and Vice President of Jilla Pariಷad of South Salman Khan. Then your lordship will see the last paragraph number 12 at page 75.
Yes.
The respondent number 4 has the absolute power in deciding the cases pertaining to disqualification of member on the ground of defection as laid down in section 111(3)(2) of the Assam Panchayat. The matter is under scrutiny and examined and will be disposed of in accordance with the provision and as per order to be given by this honorable court. Now your lordship will see the list. Your lordship will kindly take note of the dates. Election was declared, result of the election was declared on 11/5/2025.
Yes.
Then this independent candidate, he joined the Congress party on 17/5/2025.
17/5.
Yes. Your lordship will please look at page 98. We are a mistake.
98 by Wahidur Rahman.
Just a moment, madam. Taking it because your lordship will find it Noor Yasmin, page 98, and except P1 page. This is the receipt.
This is the affidavit filed by one Wahidur Rahman.
That's what number 6.
That's what number 6.
Yes.
Yes.
Independent candidate.
So what is this P1?
P1 is the receipt issued by the party president of the Congress accepting the membership.
This is
By the
on,
district Congress committee.
this is on when? 17/5.
Yes.
Where is the date?
Now you'll also look at Annex P2 information. It was informed on 17/5. Maybe it was earlier, but we take the date as 17/5 when the information was given to the President Assam Protest Congress.
Yes.
And at the bottom, you'll also find the endorsement is also of the 75/2025. And in the next page, at page, the General Secretary has accepted it on 18/5. APC.
No, what is, no, I mean, this is an admitted fact. There is no dispute.
Because because they were trying to show that this person is an independent candidate. He's not an independent candidate. He has become a Congress
He has become a Congress post-election.
post-election. And this election for the president and vice president was held on 7/8/2025. Prior to election of the president and the vice president.
No, what?
7/8/2025.
What is the date? About?
For election of the president and the vice president of the Jilla Parishad.
No. The election, the results were declared on 11/5/2025.
Original direct election.
Direct election.
Indirect election was on 7/8/2025.
Indirect election means the for the post of presidents and all.
Yes, by the
Initially, 4 members were elected.
Yes,
Correct.
yes.
And out of the 4, there should be 1 president, 1 vice president.
Yes.
Then 3 were originally from the Congress and 1 was independent. Then the election happened. This election happened on 7/8.
Before the election happened, he joined Congress and Congress membership was accepted.
So 17/5 he joined Congress.
Yes.
And 7/8/2025 election happened for this president and this thing. And there 2 votes happened.
Then
And Congress is saying that like we have instructed, we should have whip to elect him.
No, district committee.
District committee has stated that we have
We have-
issued a whip to elect him. And your client did not vote for him, but
That is the presumption and assumption.
then how come it will be 4 and 4? That 2 ways to 2 if you do not vote?
No, maybe he has voted for me, I have voted for me. Well, there's a very interesting case. In case it's all secret. That's
See, correct.
No, but this secrecy will remain. Maybe I have
So
voted for him, he may have voted for me.
now you are the elected one, present one, right? You are the elected president, correct?
Yeah.
And the Congress is saying that like this Mr. Das's client should have been the president and he should have been the vice president.
Yes.
Correct.
Yes.
Now the thing is that like you did not. You yourself projected. That is the case. That is the case. Yeah, you yourself projected and you became, because with the support of the independent one who has become a Congress party. You also became.
And DC has categorically said that it is.
Now tell me.
It is a secret ballot. There cannot be a determination as to who has voted to whom.
No, but thing is that for electing this president and vice president, the nomination has to be filed.
No.
Nothing is required.
It's a meeting, it is held, resolution. That's why I told that the resolution of the deputy commissioner is very important on that particular day of the meeting. At what time he filed the objection. If the objection is prior to the tossing of the coin, then it will be take a different turn.
So something like that happened. That like they thought like he will become president and he will become vice president.
Yes.
And in the meeting you said, no, I also become. I would also like to stand for the president. Then the independent person who is.
I don't know who independent voted.
But like on what presumption you are saying that like, he will vote for you?
No, I don't know. I don't know for whom he has voted. He also
No. How he is standing? He is standing for himself.
There is a very interesting observation of the Honorable Supreme Court in one of the judgment. If I voluntarily declare that I have not voted for him, then it will be different. Here I have not done that.
No, but
direct Supreme Court judgment on that point. That's why.
No, but
that's why the deputy commissioner has said.
But 2 persons are standing.
Yes.
Now, if you say that like no, you are standing, but like you have not voted for himself yourself, you have voted for me.
Well, how do I know for whom these 2 persons have voted?
Anyways, that's difficult to.
Now that's a disputed fact. How they will know for whom I have voted and whom I have not voted? Deputy commissioner himself says that it is difficult to determine because it is all by secret ballot. Your Lordship will see the one. That's why I was telling that the record will be necessary to determine the procedure. What has happened? I when this provision of 111 C was done, it was probably copy paste from some other act, because in Maharashtra, Calcutta, then Karnataka and all, they have a special procedure which is slightly different from that, from our provision. In the cut paste matter, probably they had left somewhat. That's why I wanted to look for the original gazette notification of 2023, but I could not find it online. That's why I'm not sure, because here it appears that some words are missing, because your Lordship has now. Here Your Lordship, kindly look at 2026 SCC 812. Lakshmi Singh and another person. Now, Your Lordship will see.
Para.
First, Your Lordship, look at paragraph number 4, limit of facts. On challenge by the first respondent, the High Court of Judicature and Allahabad, by the written judgment dated 13/9/2019, has set aside the minutes of the Jila Panchayat meeting dated 25/10/2018, approving the motion on the ground that some of the members had violated the rule of secrecy of the ballot. Reliance was placed on the CCTV footage that was played in the court to observe that some of the members had displayed the ballot by their conduct, revealed the manner in which they had voted. Then section 28(8) of the Uttar Pradesh Khetra Panchayat and Jila Panchayat Adhiniyam 1961 states that a motion of no confidence motion shall be put to vote in the prescribed manner by secret ballot.
But it's a no motion.
Then your Lordship will see the observation at paragraph number 6. Challenging the above finding, the petitioner before us have submitted that the imputed judgment is not in line with the holding of this court. Here also it is secret ballot. Paragraph number 7. The petitioners claim that the principle of the secrecy of ballot is based on the public policy aimed at ensuring that the voters cast their vote without fear of revoke, without any apprehension of disclosure. These aspects were highlighted in as requesting wherein reference was made to section 94 of the Representation of People Act 1961, which states that no witness or other person shall be required to state for whom he was listed in an election. Illustrating the importance of the provision, secrecy of the ballot was appropriately styled as a postulate and keystone in the arc of the constitutional democracy, as the electorate or the voters should be absolutely free in exercising of franchise, untrammeled by any constraint, including a constraint as to disclosure. Even a remote or distinct possibility that at some point a voter under compulsion of law can forced to disclose for whom she has voted would act as a positive constraint and a check on the freedom to exercise of franchise. It is the policy of the law to protect the right of voters to secrecy of the ballot, albeit this right is something which can be claimed only by the voter himself against unwarranted disclosure. This is important, my Your Lordship, kindly take it. Section 94 of the Representation of the People Act enacts a privilege in favor of the voter in that no one can compel him to disclose for whom she had voted. But the privilege ends when the voter decides to waive the privilege and instead volunteers to disclose as to whom she had voted. Here I have not disclosed to whom I have voted. No one can prevent a voter from doing so, nor can a complaint be entertained from any, including the person who wants to keep the voter's mouth sealed as to why she disclosed for whom she voted. Once the voter chooses to waive the privilege and volunteers to disclose, there is no contravention of section 94 or any other provisions of the RT Act. There is no illegality involved in the disclosure by the vote. So here Your Lordship will see the section which entire process is secret is that is section Rule 50.
No, it is not. That is not doubted.
Yes.
That is not doubted.
How
That it's a secret voting.
Yes.
It's a secret ballot. There is nothing.
Then how they can presume to whom I have voted or my learned friends client?
There are 4 persons only.
4%, madam. They have said there is no determination on that. They have voluntarily disclosed themselves that they have voted for themselves. So we and we have not voted. So all are from the same party. Toss of the coin when the fate of the result of the toss did not went to their favor, then they have raised this grievance. If they had owned the toss, this grievance would have not been there.
That is obvious.
That's why once you subject yourself to all these things, now it's too late to cry for that look, we had a whip and you should have voted for us. There is no provision of whip in this Panchayat Act. What whip has not been mentioned anywhere in the Panchayat Act. It says contrary to the respective political party.
No, see, now this election of president, vice president happened on 7/8/2025.
Yes.
Prior to that, prior to, that means like 4 people were from the Congress.
Yes.
Correct.
Yes.
Now, a person out of the 4, 1 person is to be elected as a president.
Yes.
Right?
One vice president. Yes. One president, one vice president.
And the party says that this person will become a president.
Yes.
And you are supposed to vote.
Provided they have the power to issue that whip. Where is that power? Panchayat Act doesn't permit for issuance of whip.
But you have voted contrary to this because
No, that your lordship will not
no,
say.
who has nominated? I mean, who will do this mechanism of nominating a person for president? How it will be done?
But that's why I was.
No. You tell me. See, there are 4 people.
Yes.
So there must be some agreement that he will become prior agreement that he will become president. I'll become vice president, something like that. So now there is some pre-agreement. On their allegation is that there wasn't pre-agreement, but you didn't abide by that. So you have gone contrary to the party policy.
This procedure is not contemplated under. It is only in the meeting which is convened by the deputy commissioner. Only there this procedure of election will be determined. It's not in sitting.
Though now, think of a situation. Now the 4 persons from Congress, everyone is saying that I will become president.
Yes.
Then what happens?
Then what?
Then what happens?
Then ultimately it will be decided by secret ballot. And if it is equal, then point. 4% can say I can become a president. The law doesn't prohibit the 4 persons to become a president or a vice president. Anyone can say. And out of these 4 votes, as on date, there is nothing on material on record to show. It's not that they have taken a photocopy of the clicked the picture of their voting paper and produced before this court. That's not there. Nobody knows whom these 4 persons have voted. That's secret.
It has become 2:2, so it's apparent.
Presume this is not a case.
It's not 100 voters or 70 voters. There are 4 voters. So it's a simple mathematics, Mr. Kumar.
No, I will not disclose to whom I have voted, and I will not believe their statement also to whom they have voted.
So you want to say that
these 4 people has to decide who has to be the president, who has to be the president. All the 4 people have the right to become the president and the vice president. And the section 111C is clear. It is only contrary to the respective political party, which prohibits cross voting and not internal choice where all the candidates belong to one party, madam.
Yes, that's all.
And now your lordship will see. Here what has happened. These 4 people could not decide whom to elect the president and the vice president. There is disagreement between 50-50. That's why they have contemplated the procedure under 45 toss. And both the parties have subjected to the toss. Now it's too late in the day to say if they had objected before the toss, then the situation would have been different. That see, we will not subject ourselves to the toss, or will not subject to this your toss of the deputy commissioner because there is a party whip. Now they are stopped from saying all these things.
Okay, anything else?
But yes, but that's all. And your lordship will also take note. Just your lordship, for a moment, only kindly look at 50.
50.
Secrecy of ballot is mentioned.
50 of rule.
Just a moment. 50 of the rules. Election of president and vice president of Jila Parishad.
Yes, where is that? 50 of rule.
Rules of 1995. First, your lordship will see, one is that it talks about the meeting time, fixing, etc. Your lordship will kindly go to 4, the procedure. The deputy commissioners shall immediately after vote taking as under call upon the members present as under subsection of section 65 of the Act, propose and second names of persons from among themselves as under section 1 of section 70 of the Act for election of a president and vice president of the Jila Parishad. The deputy commissioner presiding over the meeting shall record the name of each candidate proposed for different offices and shall reject any proposal if the candidate refuses to stand for election. Then your lordship will look at 6. If more than one candidate are proposed and seconded against each of the offices, the deputy commissioner shall conduct the election in the following manner. Now your lordship will see 2, the bottom line. The deputy commissioner shall provide a compartment screened from observation by any other person in which the members can mark the ballot paper. Unlike in the Rajya Sabha election or the president election, in the table, the nominees of the political parties are there. You have to show after the voting that I have voted, I have followed the party with. Then you'll have to look at the next provision. Because why this secret ballot is given? But it is only to have the freedom of choice and the confidentiality of voting. Your lordship will see 6(3). He shall then instruct the members to enter the compartment one by one and put a cross mark against the name of the candidate of his choice.
666. Where? Which 6?
6(3). The deputy commissioner shall thereafter.
Ha.
The deputy commissioner shall thereafter hand over one such ballot paper as prepared under clause 1 to each of the members present. After putting his signature on the back of each ballot paper, he shall then instruct the members to enter the compartment one by one and put a cross mark against the name of the candidate of his choice in the ballot paper supply. To this process also, there is no objection. Look, we have a party whip, there cannot be nomination of 2 candidates. There is no objection at this stage also. Hold it and then insert it to the respective ballot box kept in front of him. Then your lordship will see. If a member is unable to write or physically incapacitated from voting, deputy commissioner shall at the request of the member take him to the screen compartment, ascertain his choice, and accordingly mark the ballot paper, fold it, and then insert it to the concerned ballot box. The deputy commissioner shall ensure secrecy of the ballot paper. The Panchayat Act is very clear that so far voting is concerned, it has to be by secret ballot. Then your lordship will look at 9.
No. Okay, I got it. Now tell me one thing. There, I mean, all 4 members are Congress.
Yes.
So 111C. How it will be applicable now?
It will not be applicable. They cannot. It is only if there was a BJP candidate and others, say like AGP or there may be independent AIDF. Then that. Because I have checked the other acts, but I can produce all those acts of Tripura, Karnataka, and all. Their provision is different, like our Assam Act. Assam Act, but there are some words are missing. They have copy pasted, and that's why they have those words. And they must have done it deliberately.
Okay, but I got your point. Now who else? Who is?
You'll also see 9. Because of this 9 only, it was referred to coin system 9. In case of equality of votes in either of the state election, declaration of election shall be given by the respective deputy commissioner in the manner prescribed already. So, to summarize is that, so far the 111.
So yeah, I mean, your argument is the 111 is not applicable.
Not applicable. First is, they have failed to show that they have the power to issue the whip under their own constitution, or just like the articles of association of a company. There is nothing on record to show that they have the power to issue the whip.
Whip for nominating particular one person as president.
Yes, that's whip. That's the meaning of the whip. In some act, they have issued the whip in Maharashtra, I think they have used the word whip. There, even the independent Congress or different parties can march together after the election and they can form a group among themselves and they say that we want this particular person, irrespective of any party, as the president. Maharashtra is completely different. So far, the Panchayat election of the president. Assam
Okay, I mean, to summarize, your argument is that there is no power of whip in this case. And so if there is no power of whip,
it ought to have been issued by the state Congress party, not the district one.
Okay, we'll hear Mr. H.R. Chaudhary on this.
But my friend appears only for the district. That's number one. Second is, that so far 11 this C is concerned. The respective political party is only to tackle cross voting and not between the internal voting of the members. And since it is a secrecy of ballot, nobody knows for whom I have voted. In the affidavit, they may say now, due to different pressure, they may say that I have voted for myself. Nobody knows, madam. And Deputy Commissioner has said it is not possible to examine. And third is that when the coin was tossed for the election of the president and the vice
they didn't
president,
raise an objection.
And so now they cannot come and say. And Deputy Commissioner has already done this exercise of who will be the election and who will be the president and the vice president of the Jila Parishad. My lord, at this stage, no useful purpose will be sending back again to determine the same facts which he has already determined. In the affidavit at last paragraph, it has said that I'll be bound by any orders of the court. For that, you don't need to state in the affidavit. Everybody is bound by the magistrate. and
No,
the
no, they
orders.
are saying that the process is still going on. They're
Process
saying.
means, well,
Because they are,
because what has happened since there was
See,
no stay, my papers and everything was.
and the deputy commissioner has said that panchayat section 11 is not applicable, it's not there. He's saying little bit, I mean, his statements were a little bit wide. It's not concise. And another thing is that he's saying that he be, since there are some complaints, he is now considering this. Now, at this stage, whether this court should look into this matter or that let it go to DC. That is the question we need to decide.
Paragraph number 12, here, deputy commissioner has categorically said that the respondent number 4 has the absolute power in deciding the cases pertaining to disqualification of member on the ground of defection as laid down in section 111(3) of the Assam Panchayat Act. Then that line, my lord, which they are saying that the matter is under scrutiny and examined and will be disposed of in accordance with the provision as per the order to be given by the honorable court. So, although he has stated in this line, this affidavit, but the entire process under 111(c) 3 and 4 has already been completed.
No, he hasn't taken the issue or like the element of disqualification. He never thought about this at that point of time.
That's why he has said matter is under scrutiny and again it will be disposed of in accordance and as per order to be given by the honorable court. This is the safe.
No, this, I mean, that is a different thing. I mean, that we are not, whatever direction will be given and that we are not influenced by that line.
Yes.
We are only saying that whatever, I mean, that he's saying that since some complaints are there, the disputes are there, then they will consider it. And it's under consideration. At this point of time, when he's a statutory authority to consider this and decide this, whether court should, look into this or court should refer it back to him. That is the question.
The court looking at the factual background of this case.
Correct. That's
on its own merit instead of remanding matter to the deputy commissioner.
Correct. So since there is an alternate statutory authority, whether courts should interfere or not, that has to be looked into. We'll hear Mr. H.R. Chaudhary and other people, then we'll decide.
Madam, my learned friends has traveled beyond that here, madam. I think matter is very simple, madam.
No, he's only his only contention is that there is no power of whip.
Now you kindly see what 2113 says, madam. Contrary to the respective party, madam. That your lordship, it shows. It means that there is some direction, madam, contrary to the political party, madam. In respective direction. What does it mean, madam?
But he hasn't voted for somebody else. He has voted for you only. I mean, one of the Congress candidates only.
No, I am not on that, madam. I am not for the candidate. Whether I have issued on, I am not on that, madam.
But you have, whether any material on that you have issued a whip.
Your lordship, kindly page 37.
Page 37 of?
Page 37 of the 4962. I have to take my
4962, yes. Page 30?
page.
38? No, 37.
Page 37.
Yes.
Your lordship, kindly see, madam. Record dated 2/8/25.
So prior to 7/8, okay.
Prior to 7/8. Prior to 7/8. And otherwise, madam, your lordship, kindly note one thing, madam, because election was held on 7/5/25. Result was on 11/5/25. Your lordship, kindly note that, very important, madam. Election was held on 7/5/25. But he contested admittedly as an independent candidate, madam.
Yes,
So he is an
admittedly
independent candidate for all practical purposes, madam. That will not be treated as a Congress candidate, madam. Because it is indirect election. That was the direct election, madam. And there in the nomination paper, he declared by himself that I am the independent candidate. So now he cannot say I have subsequently joined and I may be treated as a Congress candidate. Congress candidate will come from that date, madam, when the nomination files the nomination paper. Then only he will say that he set up a Congress paper. But your lordship in the Panchayat election, so for Gau Panchayat, Anchal Panchayat, no political affiliation. Only respect to
Ila.
position, political affiliation. My lord. So once political affiliation is there, my lord, automatically this will come. 10 schedule of this section 1113, that will come, my lord. So he's saying that by joint post-election, it does not make him Congress candidate, Congress candidate. It does not make him Congress candidate. So that's why he's under that, he's bound to he's fall under this section 112, he might have. Contrary to the respective political party matter.
Now, Mr. Kumar's candidate, he was independent or he was the other one?
Congress.
He was a Congress.
So far as far as 6 is concerned.
6 is concerned.
I have directed that this person, the writ petitioner, is to be, who was given, so you vote for that.
So you have written this letter on 282025. So you have written to Tanjina Khan and Mrs. Mizuna Begum.
Yes. So because I do not have any fault on the independent candidate, my lord, because his elected is independent. So my group will not apply to him. But I don't claim as Congress candidate.
But he has joined Congress after.
Subsequently joined, my lord. He is Panchayat Jila Parishad member is independent. He cannot say officially he is an independent candidate. Officially he is an independent candidate. Joining as Congress subsequently in my party he might be Congress member. But so far Panchayat election is concerned, he is an independent candidate.
Okay.
Then this is the letter 37 you have kindly see. What I have stated, that you have been elected as the president from our Congress party. As per decision taken by the concerned authority of Congress party on 7/8/25. 25, okay, but Mrs. So-and-so is selected as a Jila Parishad, Vice President of our Congress party. So you will have a directive to attend the meeting and cast your vote in favor of no yes consent. As Jila Parishad Vice President. Your worship, what it was.
Yes, yes.
Then kindly see my lord, page 42. Again, I am writing matter on 7/8/25. 7/8.
On the day of the election.
On the day of the election.
So you are reiterating that like this Yasmin Sheikh should be president?
Voted for vice president. Then after the election, my lord, kindly see page 57. I inform the district commissioner. Immediately after the next day of the election, with the election, my lord, I get a complaint that the British aforesaid in the Anti-Party Act of so-and-so.
What about the president? You are saying about only vice president?
Vice president.
President was.
No, president, but so far I am concerned. I have given whip to respondent number 5.
No, you have given only for vice president or like president also?
Both.
The president, where are the documents?
In my petition.
Yes.
Huh?
My petition, it is there.
It is there.
Item 14, item. No?
Okay, so ultimately this is not disputed that you have given this.
Yes.
But he says that there is no power. That's a different thing. Okay.
So by now question whether he is saying that I do not have the right to give you. Your friendly, what I confine to my agreement on the Congress. Once again, my Panchayat. Once again.
So you are saying the contrary word.
Contrary word.
The contrary word is basically.
Your worship knows that they should have written contrary to the direction or something in the. But the intention is what is like.
But if your parties intimate something, so if somebody doesn't act according to the intimation,
this is the meaning of the contrary.
So that becomes a contrary. So that is your.
Yes, this is my case. Now I take your worship.
Let me point out that the vice president is never put to change. You know, should do the petitioner is to elect second. In the prayer, you know, should see they only change the president, not the vice president.
I am not on that matter. By purpose, I still.
So your argument is basically 11(3)(c).
Yes.
11(3)(c).
Yes.
Contrary means that any kind of intimation.
Yes.
Or intimation, maybe whip or by way, whatever.
Another direction in this matter.
So if there is a contrary this thing, then it's a disqualification.
Yes. Point number 1.
Okay.
Obliged to.
You can also say amended page 47, although they have said that it was not marked to any of this persons, but they also kindly look at that document.
Copy to Gaurav Gogoi, copy to Deobrata Sakya. No, you are not, you are not, I mean, you are not required.
Serial number 6, person concerned is David.
Person concerned, maybe there are so many persons concerned, not me. And if you have to show the proof of service, so we dispute that it was also. And you have to look at a prayer, their vice president is not even under challenge. My director, Mr. Choudhury, only says about the vice president. But where is the vice president under challenge? You have to look at the prayer in Muri Askin case first.
For that, my lord, 129 applications will be filed, my lord. How we can file this before honorable court, my lord? To challenge the vice presidency, we have to file an application under 129. Our prayer is, my lord, to dispose of representations in respect of, in terms of 111, my lord.
Representations before the DC.
Yes, my lord. For challenging his election, my lord, we have to approach the election commission under 129. How it will.
I have put this one number. Can we, I have not submission, but I have adopted my senior submission. And the page 24, my lord. This is the prayer. Page 24. In the premises,
So you are now the vice president. Yes, page 24, yes.
In the premises aforesaid, it is therefore respectfully pressed that your lordship may be pleased to admit this petition, call for records of the case, and issue a notice upon the respondents to propose as to why a written in the nature of mandamar shall not be issued, directing the district commissioner Salmara Mankasa to court to disqualify the respondent number 5 as the member of the Salmara Mankasa Jilla Parishad. And the mandamar shall not be issued, directing the district commissioner to court to consider the representation dated so and so submitted by the president Salmara Mankasa District Congress Committee and petitioner, whereby request was made to take necessary action to disqualify the respondent number 5 as member of the Salmara Mankasa Jilla Parishad in terms of the provisions of the Assam Panchayat Act 1994 on the ground of casting her vote contrary to the decision of the party. And certiorari shall not be issued for setting aside an impugn finding of the respondent number 4 reflected in the so and so. And mandamar shall not be issued directing the respondent to post the decision that equal the impugn finding of the respondent number 4 reflected in the minutes of the first meeting of the Jilla Parishad dated so and so upon hearing. So, my lord, in both the repetitions, there is no such prayer regarding the disqualification or challenging my election of as a vice president.
But page 26, in the pending disposal.
By pending disposal of the rule lordship in interim, may be pleased to direct the state election not to issue the notification, notify the election of the vice president as Salman Sawaj.
So that's what they're saying, that like, they have already filed a petition there.
That to notify, but prior to filing of this petition, that has already been notified. As well as the respondent number 4 repetitively. And on the other hand, despite my joining in the Congress party, no such letter has been issued by the DCC to me to voted for so and so. No such letter. It is clarified, my lord, earlier my letter is already showing the letters in the name of 2 persons only. That is Mirjuna Begum and the Tanjina, not to me. And in fact, my lord, the membership receipt that has been issued by the DCC, not by the APC.
How does it make difference?
Now they said that in their petition, they said that they have no knowledge regarding my joining in the Congress party. In that respect, I have sufficient. And since I have joined in the Congress, so among the 4 persons all are belong to Congress party. So my humble submission is that since my election has not been challenged in both the petitions, so that has may not be interpreted. And in respect of the others, the 4 cases from the Congress party. So there is no application is under 11.3.3.
No. They are saying that there is a intimation given to all the members saying that like this is one person is a nominated president and you should elect him. But like you have not done so, that is their case.
Yes, but in the Panchayat Act, there is nothing. Because in the meeting itself, the members, in respect of Anchalik
No,
Panchayat,
I mean,
Jila Parishad and others.
Panchayat, I mean, there is something. Why are you saying it's nothing? I mean, otherwise, then why 111.3 is there? Why this word of contrary is there? Why disqualification is there if there is nothing?
My understanding is that matter subject to.
See,
correction of the
in
lordship.
Panchayat, under the Panchayat Act, Jila Parishad election, party affiliations are there.
Yes.
Since party affiliations are there, that is why 111.3 is there. And 103 is there, it's not for, I mean, there is an object of bringing the 103,
Yes.
111.3.
Yes. Yes.
That there has to be I mean, there has to be some situations when disqualification has to be brought in. Now, the question is that whether in this case disqualification is there or not. That is the case. But you can't say that like, I mean, you can't say that in Panchayat elections this 113 is not there. It's not required.
My humble submission in this respect, my lord, since all the members are from belongs to the same party. So 111.3C in respect of the changing of the party affiliation or voted or abstain from voting for the benefit of the others party, my lord.
No, the intimation was for electing a president.
Yes.
Now party has issued an instruction.
Yes.
And you have not obeyed it.
Yes.
That is their allegation.
Yes.
Now whether that can be done or not, that is the issue.
But as per the, my lord, the definition in section 111.3C is concerned that for changing the party affiliation or voted or abstain from voting for the benefit of the others party, my lord.
No, that hasn't been stated, as I said. 111 doesn't say so.
The votes or abstain from voting in contrary to the respective political party.
In
the
respective political party,
yes,
in the election of
the respective political party.
so it has been specifically stated that president, vice president,
Yes.
a member standing committee, or in voting. So if in case of a election of a president, then if a person is nominated by the party, and if you do not vote it, then it will go against the party. This thing. It is specifically stated president, vice president, members of a standing committee. Otherwise, there is no purpose of bringing in this 3C.
Yes, my lord, but my subject to correction, my lord,
It may happen that there are 100 members, and out of that, president has to be selected, and all 100 members are Congress party only. But in that situation also, if the party gives an intimation that you nominate this person, you elect this person, and if you do not do so, then you are violating that party instruction, correct? But now Mr. Kaur is arguing that how it's a secret ballot. How do you know that I haven't voted? That is his case. He's saying so.
But my humble submission, well, since the respond number 6 election has not been challenged in both the writ petition, my lord. So that cannot be maybe interfered with. And I have already joined in the Congress party, and prior to election of the state president and vice president of the Jila Parishad, I am the member of the Congress party. And that has been accepted by the APCC, which has communicated to the DCC, and DCC itself issued the membership decision.
No, I mean, this provision is very clear. This provision is, I mean, there is no ambiguity in this. I mean, if there is a election of Jila Parishad, and then after that a president has to be elected, then if there is an instruction, you cannot vote contrary to that. That is all. And that power that is all. And if that is by way of a whip, that is by way of an instruction, that is not clearly stated here. Correct? Mr. Das, I mean, is there anything, I mean, you want to
I'll just give a reply at 2 o'clock. Now it's 1 o'clock, my lord.
Okay.
2 o'clock, I'll just give a reply.
Mr. Nath, you have something?
Just 2 minutes, my lord. 2 minutes, I'll give a reply.
We have finally indicated the procedure which we have taken in para. Yes, or definitely in WPC 4962 of 2025 under what circumstances.
So you are basically saying you're reconsidering it.
No, para 7 kindly come to
Para 7 of
of the affidavit in opposition filed by respondent number 4.
page.
Yes, what to relevant
Page this thing, page 60, 67.
page 67.
Yes.
So for the procedure, we have conducted to have the election that we have indicated in para 8. And this is the issue which is will not be at para 7. For the relevant the provision we have quoted relevant is para page 68 last para.
Page 68, yes.
68 last para of the para. It is further pertinent to note that there is no provision in the
One second. Page 68.
the last paragraph of the
Is it para 5?
para 7 continues.
Oh, no, there's different. 1 second. Which petition you are saying?
I am referring to 4962 of 25.
4962.
Yes.
4962. Affidavit of opposition by Rahul Kumar Gupta. It should be page 70. Page 70 as directed by.
Well, para 7 starts, yes, please kindly come to the next page. Para 7, last paragraph.
No, I think there is some page. You are reading para 7. Para 7 is at page 72.
72. I'm not sure.
From there?
From there, the para, the provision we have quoted. Kindly come to the next page. I'm reading the relevant provision. In the instance, petitioner referred to section 3(1) C of the disqualification of respondent number 5 on the ground of election. It may be noted that both the candidates proposed for election of president belong to the same political party. It may also be noted that though the respondent number 6 so contested and owned as an independent candidate. Subsequently, he informed that he joined in INC party. It is further pertinent to note that there is no provision in the Assam Panchayat Act 1994 as amended and the Assam Panchayat Constitution Rule 1995 as amended to detect or identify the Jilla Parishad member or members for disqualification for their acts as laid down in section 111(3)(1)(c). So that is the understanding of the respondent number 4 on that day. But subsequently, he said that since they have filed a representation, it's under consideration. He will take a decision of that. That is in paragraph.
So this statement is not correct. There is a 11th 11131C that has been specifically brought in with a special object of disqualifying because there is an affiliation.
If it is cross-voting in case of inter-party, that may come. But this is not in-house. So they are in-house arrangement.
Correct, but thing is that like
disqualification doesn't come. It is up to.
No, I mean see 1-1 disqualification. No, I didn't get it. What did you say? Disqualification will not come. Why?
It comes only in case of cross-voting. If they are from a different party, then in that case it will come. In case of Jilla Parishad members or members of a political party shall be disqualified if he or she come to see votes or abstains from voting in contrary to the respective political party in the election of member of the standing committee or in a voting of a no confidence motion against any one of them.
So it doesn't talk about political party. It talks about the election of president, vice president. So president, vice president. See, I mean, in one Jilla Parishad, if there are 5 candidates from the same party, and in that case, if the party says that this person should be the president, and there is an instruction given to you, then if you do not vote it, then what happens?
Kindly see, here the emphasis is given on the political party.
No, correct. One political party.
And in clause C also, 3(1)C also, the stress has been given, emphasis has been given on the
respective political party
Correct.
in the election of president and vice president. So they should not that defection thing comes because one party, the member of one party votes for the other party, and the situation of defection comes.
No, it is not exactly a question of defection. It's a disqualification. Disqualification, whether disqualification can be done or not on the basis of now here also the same situation has happened. There are four members. They are all from Congress. But only grievance is that though the party has intimated you that that you should nominate this person as a president, you have not abide by that. Now whether that will call for disqualification or not, that is the issue.
But that calling of the instruction of the political party is up to the members. That instruction of the political party, the respective the political whatever whip, they are calling it whip or instructions, it is to be followed by the members. Right?
Yes, members.
Members. And 3(1)(c), it is a disqualification if the political party and members of a political party shall be disqualified if he abstains from voting on contrary to the respective interest of the political party. So the inference may come, inference will come if it goes against the political party in favor of the other party. So to prevent that situation, this is the outside my humble submission.
Okay.
That is why the deputy commissioner has said in the affidavit.
No, now thing is that deputy commissioner has admittedly saying that like this is under process. Since there are some representation, we'll decide the matter. Let him decide the matter.
Yes, to that extent, that statement is very correct.
So that is your stand only.
In fact, in para 7, that is why I have indicated para 7 and para 12.
So there are two things. One thing is that the court can decide the matter itself. And another thing is that since there is a statutory power given to the DC, and the DC will be having all the materials before him, rather than the court is having it. So if DC can decide the matter, okay, we'll finish it up at 2 o'clock.
Yes.
2 o'clock.
My business partner to record. My business partner to record.
Yes, yes. Yes, Mr. Zikas.
Yes.
I think they finished already.
Yes, only I just give a reply.
One thing is that like that learned senior government advocate was saying that this 11C3
cross voting.
I mean that is he's saying that like that will applicable to only when the two parties are there and there is a cross voting.
I think that argument, great respect, but is not misconceived. Because what my learned friend has raised the point about 113, if you see C, votes or abstains from voting in contrary to respective political party in the election of the president, vice president, members of a standing committee, or in the voting of a no confidence motion against any one of them. He is saying that this is not applicable, it is a matter of cross voting. Where is that mention about your cross voting, my lord? What I understand, that's what he said.
No, he's saying that's what he's saying. Like there is only one political party here. There are not two.
No, there is no political party. There is only one was independent and one political party. Now a ticket. I have understood what he said. Ticket which was given to these political three parties, three members from Congress. A ticket was given on the basis it is contested. Independent was independently he fought. He originally was not a congressman.
He joined subsequently.
Now, if your lordship looks into it, the wording of 1113, see, my lord, see, votes or abstains from voting in contrary to the respective political party in the election of the president, vice president, members of a standing committee, or in a voting of a no confidence motion against any one of them. Now, if you see the decision that has been, now we are on a decision which has given by Deputy Commissioner. What is his decision? Now we are on a decision, my lord. You are looking into the decision that has been made by the Deputy Commissioner. We are challenging that. Now, Deputy Commissioner is saying that there is no provision or is not applicable. 113 is not applicable. This is our case, my lord. He has not taken into consideration the provision of the Assam Panchayat Act. This is the case, my lord. He has to decide. He has not decided. What is his observation? Please see it. Please see what is his the finding or observation. Yes.
In your petition, no, 4617, right?
4617. On to
Page
46, my lord. C is 46. Hold on. C 46, my lord. Now, please see, it is pertinent to mention that during the process of proposing names for election of the president, when the names of Mrs. Tanjina Khan is response number 5 and Miss Minzuna Begum, that's the petitioner, were put forward for the same post. For the said post, Miss Noor Yasmin Sheikh, who is another Congress candidate where my learned friend Chaudhary is representing and my learned friend is representing. So and so raised an objection questioning whether two candidates from the same political party could be nominated. She further referred to the provision relating to the party whip and anti-defection. In reply, now see, in reply, the district commissioner clarified neither the Assam Panchayat Act nor the Assam Panchayat rules contain any provision prohibiting the nomination of more than one candidate from the same political party. Now, he further stated there is no reference to party whip in either of this enactment, citing section 111(3) of the Assam Panchayat Act in relation to anti-defection. District Commissioner further explained that no provision under the said act applies to disqualification of a candidate belonging to political party in this context. With great respect, the observation made by learned Deputy Commissioner, we disagree with this observation that has been made. He is going against the provision under 113 of 1C of the Act, from where it is his observation contain any provision prohibiting the nomination of more than one candidate from the same political party. So he said that there is no procedure which has been laid down. He said that I could not find any provision. He said that contain so and so, neither nor the Assam contain any provision prohibiting the nomination for more than one candidate.
So he's saying that like if there is, I mean, if there are 100 candidates from the
Yeah.
same political party, then there is no prohibition. I mean,
100.
there is no prohibition in like from the same party, two person
Then, my
contesting.
lord, the entire the provision of this will be frustrated. That was the first time they introduced this under the Panchayat Act. Anti-defection law was brought for the first time. There was no provision as such. Now, kindly see the wording. Votes or abstains from voting.
So it's basically you are arguing on the word contrary.
Yes.
So contrary to what the instruction was, or whip was.
Yes.
When you are using the word whip, which is not here, but the only thing is that there was an instruction. So you have acted contrary to this.
Yes, I am
so that's why you should be disqualified.
Yes.
That is your argument.
Yes. Now, secondly, my lord, my learned friend has raised certain points in this case. Yes. My lord, what he raised, his submission was that after 7/8/2025, when the election has taken place in front of Deputy Commissioner, the election of the President of Jilla Parishad and the Vice President, then he said, after tossing, when it was tossed, because it was equal, then there was a toss. So he said, we did not raise any objection. We did not raise any objection. That's what I have been told, I have noted down. He said we did not raise any objection. Now please see 3 of the letters where it is overlooked and we have raised objection. Number one, please see the letter of 4/8/2025.
Page?
4/8/2025, page 35. See page 35. Please see at page 35, 4/8/2025, when this happened, my lord, on 7/8/2025. Now, this is to the district commissioner so and so, Asimara, and the candidate Merzuna and Noor Yasmin Sheikh. What you got it? See this, my lord.
So you have pointed out that these provisions are there.
One. This is one we pointed out. Now, secondly, now see the letter of 7/8/2025 at page 39. The district congress president, DCC, he has informed the district commissioner prior to the meeting on 7/8/2025. Now during the meeting at page 46, kindly see. Yes, and which I read at page 46.
Yes.
So this is, I have given answer to it. It is not a case that it is not been, we did not raise any objection. We raise objection. Throughout we raise objection. 2/8/2025, your lordship has seen the letter. 2/8/2025 at page 34. 334, my lord. Is
So
the
it has
letter?
been sent to respondent number 4 and 5,
Yes.
5 and 6.
Yes, because respondent number 5 and 6 is belong to the political party. Sorry, 5. 5 and a writ petition.
5 in the writ petition.
Yes. So we will send to them only. This is question of the Congress of People. It is a formation of the District Congress Committee as per rule. So this is my reply.
Respondent number 6 is, independent.
Yes.
Earlier independent. Now you have become vice
Page
president.
44. Yes. Now my lord will kindly see page 44. Now his contention, nobody knew who has voted whom. That is his contention, my lord.
Yes, secret.
Now please see 44. Please see 44. In response, Noor Yashin, member is not Islam, it is Yasmin, member of number so and so, member number 2 Kalapani Jila Parishad, proposed the name of Mirzuna Begum. Right? Now, member, that is Mirzuna Begum is a petitioner. Now, proposes my learned friend's client. Now, member of so and so for the post of president. And the proposal was supported by Mirzuna. Subsequently, now see, Wahidur Rahman, that is an independent candidate, member of so and so, proposed the name of Tanzina Khan, that is respondent number 5. Right, my lord? Member number so and so for the same post, and the proposal was supported by so and so. So where is that? Nobody knew whom was voted. That is not correct. 2 and 2. Where is the question of a secret? It's known. This is what. Secondly, my lord, if you see paragraph 12 of our writ petition, see paragraph 12. Paragraph 12.
Yes.
Paragraph 12, হয় না? It is paragraph 12. That the petitioner beg to state it on 7/8/2000, the petitioner, respondent number 5 and 2 other elected members attended the first meeting convened for the election of president, vice president, Jila Parishad. After commencement of the proceeding, the respondent number 5 projected herself as a candidate for the post of president in contravention to the decision of South Salmara Mankasar District Congress Committee taken in meeting dated 26/7/2025 and proceeded to cast a vote in her favor. Upon completion of voting process, it was found that the candidate for the post of president has secured an equal number of votes. Consequent respondent for decide the election for the post should be determined by tossing of a coin. The respondent number 195 is declared elected president of Jilla Parishad. Petitioner further begs a procedure laid down in rule so and so, tossing of a coin. Now please see his reply at page 63. This is response number 5. Response number 5.
Response number 5.
5, paragraph 9, last paragraph.
No.
Hmm?
1 second. Response number 5.
Yes.
Yes, right.
Well, reference line.
Tanjina Ahmed Khan.
Yes. See, 9.
Para.
Para 3, my lord. Page number 63.
The pages are not properly done.
63.
Paragraph
Paragraph 9.
9.
Yes. See the third paragraph.
With page 94.
Yes, it will be 94. 94, para 9.
In response thereto, Wahidur Rahman, ZP member of so and so, who had joined the Indian National Congress subsequent to his election, proposed the name of deponent, response number 5, for the post of president of Jilla Parishad. Upon initiation of the voting process, all 4 elected members casted their votes. After counting, both candidates secured an equal number of votes. So where is that denial? We have not voted. Where is that denial? There is no denial. And they themselves stated the independent candidate proposed her name, and it was 2/2.
So that means that the vote of independent candidate and your vote, you have got it.
Proposing is different thing. I may propose for the Congress candidate, but at the time of the voting inside that box, I may give to some other candidate also. But you cannot presume.
You got 2 votes.
That 2 votes, their 2 votes may be in our favor. Our 2 votes in their.
So but Mr. Das's candidate should have denied their voting.
Now, for that purpose, who will decide? That purpose, decision will be the deputy commissioner. Let him decide. Let him decide the issue. My lord, they cannot bypass the provision of this act. What they are saying, my lord, how can they bypass this provision? This has been introduced. This provision. Can they bypass this provision? This is the first time this provision has been inserted.
No, it has been inserted in
See, Mr. Kumar,
This is 24. 24.
Object is very apparent. You know about this. Now bringing in this to the Jilla Parishad, because the party affiliation and party loyalty has to be there. That is the object, right?
Yes.
Now, if there is a question of party loyalty, then the question of disqualification comes. Now, whether now it is in this case, whether there was a disobedience of the party stricture or not.
My lord, I will finish it then. I'll just say why this provision was inserted.
And that's
This
what
provision was borrowed from 10th schedule. There is no doubt about it, 10th schedule. And how it was dealt. One judgment of the Supreme Court makes very clear, my lord. I'll place that judgment. Please look into that judgment. 2006, 7 SCC, phase 1.
Party number.
Kuldeep Nair and others, that's the Union of India and others. Please see 2 paragraphs. Kuldeep Nair. Para 382. Lordship got it?
Para 382.
382, first para 382. That Lordship got it, 382.
382.
The 10th schedule of the Constitution recognizes the importance of the political parties in our democratic setup, especially when dealing with members of the Houses of Parliament and legislative assemblies or councils. The validity of the 10th schedule was challenged on various grounds inter alia, that a political party is not a democratic entity and the imposition of whips on members of parliament was not in accordance with the constitutional scheme. Rejecting this argument, this court held that it was open for parliament to provide that its members who have been elected on a party ticket act according to a decision made by the party and not against it. Now, please see now 458, which makes it more clear now. See 458.
458.
Yes, now next paragraph, see 458. The contention, 458.
Yes.
The contention that the right of expression of a voter at an election for the Council of State is affected by open ballot is not tenable, as an elected MLA would not face any disqualification from membership of the House for voting in a particular manner. He may at the most attract action from the political party to which he belongs. Being a member of the political party on whose ticket he was elected as an MLA, in the first place, he generally expected to follow the direction of the party, which is one of the basic political units in our democracy. So once this party, my lord, which belong to Congress, which the independent has supported, she belongs to a Congress party. She has got the ticket from the Congress party too.
And after getting the ticket, she is returning you.
That's the case. And that's what the Supreme Court has observed in these two paragraphs. That's my humble submission. Let it go before the...
Who is
my lord, just to end up, my submission before this court is, let a direction be given to the Deputy Commissioner. In the meantime, his observation, whatever minority, it should go. And there are other, my lord, CEOs, CEO, whoever, my lord, let them continue. But if it is an illegal act, in 1 second also it should not continue. That's my case, my lord. Let it be decided as shortest as possible in a period of 15 days. Let him decide the issue. This illegal order, if it is found, I am saying if it is found, on the face of it is illegal, he should not continue, my lord. If it is illegal, if your lordship finds that this is against the provision he has acted, if it found, if your lordship finds it, this is the argument, well, then he should not continue, my lord. Where is the question of continuing it, my lord? It's an illegal act, so he should not continue. That should go. And what is the Deputy Commissioner replied? Is he will follow whatever direction that is passed by the...
Now tell me one thing. If at all the court comes to either way,
yes,
comes to a finding, then what happens? Whether it's, I mean, still it's required
to
send it to the Deputy Commissioner.
There are two issues. One issue, court decides the issues that no, we'll decide it. That he has taken some decision in it, so now we'll decide it. Now this option is open for this court. Now if the court finds that no, two representations are pending, we'll give a direction to Deputy Commissioner dispose of, and this is a provision. That option is open for this court. Either to decide it, your lordship can decide the issue by not sending to Deputy Commissioner. This is what the Act says. Either your lordship will ignore this 113. That's the position, or send this back to the Deputy Commissioner decided. There is no dispute that your lordship can't decide the issue. What I am saying that two representations are pending. He has not taken a different view altogether, my lord. He can decide it. That's observe whatever he has said that he has been elected. I am saying that should also go.
Then it has to be, I mean, then the court has to go into the merit.
Yes, merit, your lordship, we argued on merit of the case. I am deeply obliged, man.
So far, the citation that has been quoted by my learned friend is 2006 7 SCC page 1 Kuldeep Nair versus Union. This is in regard to those Rajya Sabha election, and the facts of this case was completely different. as I have told earlier in my submission.
But this is a ratio.
No, this ratio is respect of a Rajya Sabha election where you have to show to which party you have voted after you voted. Then the disqualification process for the Rajya Sabha election and the disqualification process under the Panchayat Act.
No. See. My
So your lordship
understanding, my understanding is what? I mean, this case case has been placed or cited for the purpose to show the party affiliations.
Yes.
And why, in what context, and with what object that the provision of stand schedule has been brought into.
That is in respect of the 10th schedule in Kuldeep Nayar's case. That's why it says Kuldeep Nayar's
Correct.
case.
Correct. Now, thing is that now the concept has been borrowed from there. Correct.
They have omitted some of the lines of the 10th schedule, your lordship. That's why I have read the lines of the 10th schedule.
Yes, correct.
So those
Correct.
intents are not there in this Panchayat Act.
Understood. Then you'll have to convince me why this 1113C has been brought.
Yes. First, as I have told, your lordship will see the first line of 113 again by your.
No, that I have read many
Yes,
times.
your
Yes.
lordship read it again, madam. 3-1.
Yes.
In case of Jila Parishad, member or members of a political party.
Correct.
Members or members shall be disqualified if he or she votes or abstain from voting in contrary to the respective political party. As I have already said.
Correct.
That if it was a case of cross voting, then it was. Now, if your lordship says that no, it is not cross voting.
No.
your lordship,
You are only trying to hammer on the thing of respective word.
No,
See,
your-
respective word is a relative word.
No, I have at the very beginning also I have shown, submitted before your lordship that you have to show the power of issuing of whip. My lord, now the advantage of the live streaming is that we can bring it on record. I expected the Congress party to bring on record. After this election in two of the district of Assam, there was an internal party inquiry by the state Congress party, and they have said that district committee doesn't have the power. We can bring it on record by filing an affidavit.
So they are, I mean, now the Congress is refuting it.
Yes.
They are saying like they have not, given any instruction.
No.
But the letter has gone to everyone,
No,
including Mr. Gaurav Gogoi.
That's the advantage of now live streaming, my lord. When the district committee makes, this copy was circulated to the district committee, they have produced the orders which are only in their favor, not the entire picture. Detailed inquiry is done by the 3-member committee of 2 districts. I have flag marked it also the relevant portion. That flag mark. We can bring this on record by filing a short affidavit. 2 paragraph.
It is on record. We'll accept this, but there is no question of bringing it. We are on the law point. Let the law decide, because it has not been decided by any of this court regarding this issue of panchayat. Your lordship is deciding the issue. So we accept if they have brought, let him, we are part of record. We are not influenced. We are a part of record. There is no question of.
President has also committed an unauthorized act by issuing a whip to the Jila Parishad candidate to support and vote for Ms. Marjana Begum without any authority or approval from the APC. In fact, the GS organization APCC have number of times requested the district president not to issue any whip, as the district president has no authority to issue any whip on his own. When we requested repeatedly to the DCC president to withdraw the whip, he refused to do so, rather claimed that the whip was issued by resolution by the DCC in the DCC meeting and he alone cannot withdraw the whip. Then your lordship will see the next. Then we request him time and again to give a copy of the resolution, if so taken in the DCC meeting, and also gave time to produce the same during the course of our proceeding, but he did not produce the same. The illegal issue of whip without authority has led to the issue to the High Court, taking the issue to the High Court and spreading the message of the participation of the district that this is so and so, and it is done by 3 committee members. So at the very outset only, I have said that if you can show me from your internal rules or regulation that you have a power to issue whip, then it's a different thing. First, you have to show that you have the power to issue whip. Second, if you have issued a whip, then show the resolution. If you have the resolution, then you have to show service of copy to the persons who will be affected by it or against whom the direction has to be. All these things are absent. All these disputed questions have been raised just to get the matter remanded back to the deputy commissioner. Whereas the deputy commissioner has said that it's secret ballot, it is difficult to ascertain. And this proposal of the names and all, saying that I have proposed, nominated, I have never admitted anywhere specifically or categorically that I have casted my vote for myself and not to the other party. Since they have agreed to bring this on record, because they know that this was that, because the copy was marked to that manner. And so for Kuldeep Nayak case, my lord, I was aware, I had gone through it last night, which was subsequently followed in another case of Childless Manuhai versus Parama versus Election Commission. The facts of that case is completely different so far this case is concerned. Here that the Kuldeep Nayak and the subsequent case of Childless Manuhai Parama, which was reported in 2018 9 as page 100. All the facts were in relation to 10th schedule, not in like this specific provision of the Panchayat Act, where the wording is completely different from the 10th schedule. And these complaints which have been referred regarding the toss and all, nowhere it is said that it is before the toss. It is only that the toss did not went in the.
There was a letter directly sent to him.
No, directly sent when? When?
Before 4/8.
Yes,
There is a letter of 4/8.
yeah, Lashman, see, that is on the day of the tossing.
There was a letter of 4/8. How can it be day of tossing?
4/8.
There was a letter of 4/8. And these all these letters.
But whatever be at the end of the day, it will go to the root cause of whip. Whether the district committee congress of that particular area has the power to issue the whip.
And
Their
this
state party has said no.
these letters were sent to you earlier also. Sent to the Congress.
Which one?
I mean 2/8 letter.
Yes.
It has been marked to all these Congress members. What they have been sleeping over.
No, that's why they have constituted a committee to inquire. One person will not do it. It can't be that there was a fair opportunity given to them also. They have not brought this inquiry report on record. It was marked to them, my lord. We are lucky to get it because there was some interested person was watching it live streaming. That's why we could get a copy now. But they were aware of this copy. They should have brought it on record that there was an inquiry by the State Congress Committee where they had participated in the inquiry, my lord. You cannot play hide and seek of the court. You have to bring all facts before the court. And that's why, my lord, in the repetition, your lordship will find they have deliberately not made the state congress party a party respondent. They have made only the district party who will speak in their voice. They have not made the state congress a respondent in this case.
Were there any affidavit filed by district congress? Affidavit?
Yes.
Which page? Which page? Page number?
I think Mr. HRH should be appeals.
This is respondent number 6, right? Oh no.
7.
7.
Five, six, please see 5, 6 paragraph.
61.
Page 61.
Yes. Not even a whisper of this inquiry report. Just a 4-page map.
Page 61.
61, 62, 63, and 64, and 65.
1 second. It is page nation may be different. You have taken up
number, madam. 4962.
4962.
Yes.
Okay.
Whichever.
Okay.
Now you'll also see, page 61, you'll also got it. Now you'll also see the paragraphs. They have participated in the inquiry. The observers have gone to their place to take their statement. No whisper. Even they have said that the independent had joined their party by paying the ticket fee and it was sent to the state.
1 second.
Now you'll also see who has shown this evidence. Motiur Rahman Monda, the district committee president who has signed the ticket. And he says, I have no knowledge of the independent joining. Ticket signed by the general secretary. 61, your lordship will sign an affidavit filed on behalf of the respondent number 7. Respondent number 7 is the district congress committee. Now your lordship will find at base the paragraph number 6.
Yes.
Paragraph number 6, last line, your internet page will be 4, last line. I have no knowledge about his joining in INC party, whereas his own congress has.
Now, let us see what they have stated about the whip and all. What they have said.
That your lordship will find.
Para 5.
No, the paragraph 5 is mother say that the deponent offers no comment and the deponent further wish to state that Mrs. Tanjina Khan, that is respondent number 5 of the lead petition, has deliberately violated the party whip, and she has casted a vote contrary to Indian National Congress Party in the first meeting of the Jila Parishad, and she has also proposed the name of the respondent number 6, Wahida Rahman, as the vice president candidate in the first meeting of the Jila Parishad, who was an independent Jila Parishad member. She is not an independent Jila Parishad, and as such, the respondent number 5 is live. They don't share about the resolution of taken on the meeting of the whip, which the state party has asked for it. They have not produced.
They have mentioned something on the, there was a resolution they have.
Yes.
Where is that?
Of the state.
State or district, they have stated that like these two persons will be nominated. Where is
Yes.
it?
Yes. Page number, that is page 34. Oh, sorry, this is
28.
my top.
Page
Just,
34.
in this case, it will be a little different. Just a minute. Page 37, same.
Page 37.
And actually, 28.
No, 37 is the letter.
Later.
No, there was some, yes, they have mentioned some resolution or some decision.
This is the 37 they have pointed out the first document to your option when they started the argument matter. But in the letter of the state party, it says that the state party has asked for the resolution, they could not produce the resolution. Because the flag mark portion you'll also see. Then we requested him time and again to give a copy of the resolution if so taken in the district meeting, and also gave time to produce the same during the course of our proceeding, but he could not produce the same. Your lordship will look at para 7 at paragraph number 9 of the report. Page 9, paragraph 7. 4962. The petition number 4962.
Yes, yes.
Para 7. Now, this is 4616. No, 4962. Paragraph number 7. Page 9. No document has been annexed, Madam Your Lordship said that the petitioner fails to state that after the election of the Jila Parishad, the South Salmara District Congress Committee had convened its meeting on 26/7/2025, and in the same meeting, the name of the petitioner was unanimously selected for the of the Jila Parishad. And Vice President is not even under challenge. So no document, no It is not a matter of record.
In the vice president's petition, they are only asking for a referral of the matter to the DC.
The reference is Lordship will find it page 57.
Page
The meeting dated 26/7/2025.
57.
57 of my read petition. The paragraph is second parameter. The reference is there, my lord, where I was unanimously decided to elect as the president, my lord. There is not that there is no record. That's
No, the letter that you have sent to district commissioner.
the district committee sent to the district commissioner.
Hmm.
This is 8/8/2025, case 57.
No, the letter is at 88.
88, my lord, which is still pending before the DC. And in that letter, the meeting dated 26/7/2025 is mentioned. my
Which
lord.
paragraph?
Paragraph number 2.
They have mentioned it, but there is
Page 57. So it is not that there is no record, my lord. There is record. That is why it is stated in the paragraph, that's particular paragraph, my lord. After that's it.
Well, let them even now produce the resolution if they are talking of this resolution. That's why in the at the very first we have said that let the record from the deputy commissioner come that whether this resolution is there or not. Their own state party has disowned them by saying that you are not authorized to issue the whip and you could not produce the resolution directly for whip before the inquiry committee of the state. And the state state party has deliberately not made a party because they know that if the state party is made a party respondent in this case, this inquiry report would have come on record.
But this has not been put to challenge by you, 88. They have not challenged this 88/2025. They have accepted. Why there is no challenge to it? He is producing all this report at the end of the argument. He is putting all this report. Where this report? Yes, what suppression? 88/2025. You don't mention. You don't challenge this. You are not agreed by that. Then you have accepted 88/2025.
We are not aggrieved by this
Yes.
letter. We are not aggrieved by this letter. We are not aggrieved by this letter at page 57.
Okay, then I mean we'll decide. I mean we'll decide.
I am equivalence.
We did not find any.
It's not required, Mr. Das. This one.
Where I said, my lord, let it be on record.
But I spoke to the DC. DC said that on three occasions, yes, 3 days, asking the parties to present for the hearing, they did not respond. And that is how all of the matter is.
How, my lord, what he is saying, my lord? How did deputy commissioner decide when the matter is pending? before this court? What is saying, my lord? How we, so that's what deputy commissioner with great respect, my lord.
That is the submission of the petitioner that the representation is pending before the deputy commissioner. DC is not taking any action. In response to that, one of my submission is that he has fixed dates asking the parties for a hearing. They did not turn up.
I mean, Mr. Nath, they, because it was not responded, they have come to the court. Right. I mean, the representation they have filed, it was not responded. That's why they have come to the court. Now, if the DC wants to have a meeting when the matter is sub judice, why people will go? And why DC is fixing a matter when the matter is before the court?
Because the representation is pending and the affidavit is there.
No, it is prior to that. I mean, prior to the filing of the case, they have submitted the representations and it was not responded to. That's why they have come to the court.
In our affidavit, we have said that it is under
Consideration. Yes, yes.
We have said so. And so
No, that is why it is under consideration, and they said like if court permits, then they will go ahead with it. There's nothing wrong in that.
Absolutely.
But while the matter is pending, how can he look into that?
No, the submissions have been made that DC is sitting over the matter. That is why, my lord.
They were sitting in the matter.
Even today, submissions have been made that it is pending because the DC is not doing it.
No, I mean, that's why direction is. I
said two arguments. Either your lordship has heard the matter in total. So let a decision be taken by this court whether this is sustainable or not. This is the first time, my lord, under Panchayat Act. Or if your lordship feels that I could send it, your lordship can send it. It has not been decided by this court in Panchayat case.
What Mr. Nath, what is your submission on this?
So for the provision of 3.1, 111.3.1, lordship 2 is important, my lord. 211.3 Roman 2 is also important because both 1 and 2 has to be read together. But one says the instance says 1.
মানে
111
111 2.
111.3 1C we are reading.
You are saying that 2 also.
2 Roman 2 also because
Roman
if
2.
Roman 2
Okay.
111.3 Roman 1 we are on 3 or we are on C A B C, my lord. Then if anything on A B C happens, what the DC will do?
DC will take decision, yes.
The district commissioner shall have the absolute power in deciding the cases pertaining to disqualification of members on the ground of defection. So the element of defection has to be there.
Correct.
So disqualification will come in case of defection. So defection will be intra-party. That is my submission. So since this is an issue between them, in the same party, defection will not come. So the element while deciding the matter under 111 P1, the DC has to take note of Roman 2, whether the element of defection is there or not. That is why I was submitting that it should be intra-party. If we vote or abstain from voting in contrary to the respective political party in the election of petition.
So you are saying that like DC will have power only in the case of defection, not in disqualification.
Yes, Lord.
Then who will decide about the disqualification part?
Well, disqualification on the ground of defection. The provision is very clear. Disqualification of the members on the ground of defection. So the element of defection has to be there. So the three situations for my humble submission is the three situations at Roman 1, A, B, and C. That has to be ultimately read into the condition which is at Roman 3 or Roman 2. So in isolation.
So what you are basically saying that only in the case of defection it will be described that 3-1 will come.
A, B, or C. These are the three conditions.
These are only for defections.
Only for the purpose of defection.
Defection and then disqualification.
Disqualification for disqualification on the ground of defection. So defection, element of defection has to be there for disqualification. That is my respectful submission.
Either way, whatever way, it can be sent to the DC. I mean, Deputy Commissioner decide. He has a power in this. He has statutory power. Let him decide.
Yes, the document decide that.
Your lordship is asking the matter to the deputy commissioner by humble submission before your lordship.
No, I am not decided. I have not decided.
But if then your lordship will not express on the merit of the case because that will prejudice either of the party.
But prima facie something has to be found out. Then only I can remand it back. Otherwise, how will I remand it back?
No, the power has to be discussed, but your lordship has seen.
No, I mean, see.
When they start the argument,
See, this court will interfere when there is something wrong. Because to find out something wrong, we'll have to discuss on certain merits.
That's why when they shot initially, just to remand the back by just 2 minutes submission, they thought that they will bulldoze us to the deputy commissioner. That's why we have placed all the facts and law before us.
Bulldoze who? Bulldoze this court or you?
My lord, we don't bulldoze anyone.
That's why they were so confident.
My lord.
That's why I said that let them finish the argument. I will give the reply. I will point each and every provision. After that, I will leave it to the wisdom of this honorable court.
But you are declaring. I didn't say.
Mr. Das,
Number one.
Mr. Das, DK Nath has pointed out something. I need a reply from you on this.
Yes.
My lord, 3-1.
I differ. Why? Because it will be absurd what my learned friend, with great respect, he has proposed before this honorable court, that what is the element of 113C. So what he says, that it's, if it is pertaining to disqualification of member on the ground of defection. Now then what happened to the judgment of the Supreme Court? Now, what is the case, my lord? All these three belongs to political party. Which ticket has got a ticket, Congress ticket has been given to them for the fighting of this election on the basis of political party, and the other was an independent party. Now, for an example, a ticket, my lord, a particular member of a parliament is a sitting member of parliament. Now he got a ticket from Congress and he won the election, say for a particular ex-member. Now he joins a party. So what happens to him, my lord?
No, he's not
He
joined.
cannot continue.
Now, in your case, this person hasn't joined any other party. He's in the same party. But
No.
only thing is that he has
No.
not heard the party's instructions.
What it says, that there is a constitution of this Congress, that whenever you join a particular party, primary membership has to be given from that particular district, wherever you are resident. So apparently, the district president has not given a primary membership. He belongs to that party. He got where he went to the AICC, to the president, to the AIC president, Bhupen Bora, I think. And he said, this is what I want. After the election was over, as per constitution also, he has to join as a primary membership to a district. This is a constitution of the Congress, my lord.
Coordinate bench of the Supreme Court has also discussed this with an unequivocal judgment. For this question, your lordship is not found by Edition 2 2026. The ISA Khatun judgment. It discussed 111 but line.
Independent member. 4600, we need to refer to them, we'll have to give it to
29.
Okay, now.
We require it later on also, you just take it out. We may require it later on also. Will you read out that
Yes.
particular paragraph?
Yeah. Paragraph number 29.
29.
That's 30, I will start.
ISA Khatun.
ISA
important
WBC number 7351 of 2025. ISA Khatun versus State of Assam and Bangladesh.
73?
Just a minute. 7351 of 2025. Most of the constitutional provision and section 111 of the 1993 Four Act has been discussed. A perusal of section 111 of the Act of 1994 shows that the same provision stipulates the various grounds where a person cannot be elected or voted and remain as president, vice president, or member of the Jilla Parishad, Anchalik Panchayat, and government. It is notable to take note of the fact that the legislature of the state, while enacting section 111 of the Act of 1994, did not use the phrases for being chosen as and for being, as is mentioned in Article 243F of the Constitution. Rather, the section 111 of the Act of 1994 uses the word elected or voted and remain. The use of the words and remain presupposes that the member of the Panchayat had already been elected. Subsection 1 of section 111 of the Act of 1994 contains various grounds of disqualification which were existent since the Act of 1994 came into force, except subclause J of section 111, 1 of the Act of 1994, which was substituted by the Assam Act number 10 of 1997 with effect from 24/1997, subclause A to J.
No, those are not relevant, yes.
You'll also,
Then is there any discussion on this thing?
so that 100
ISA Khatun is not in respect of 113, it is one, not 113C, not 111(3). ISA Khatun.
No, but we discuss how
No, no, no,
these
you,
provisions have come.
1 and 3 is completely different.
All the provisions have been discussed except that 3C.
That main has not been decided.
No, no, but other procedure has
Other
all been
procedure?
discussed. So far, your lordship
Why
has
other
said
procedure is
3C again, what is, to avoid just for the sake of repetition. It is completely different from Tripura, my lord, West Bengal, Karnataka, where there are specific provision for disqualification in case of violating the party whip. But in the Assam Panchayat Act, that whip what has never been used.
So you said about which paragraph?
Yes, discuss all about section 111 and all.
40.
But directly, this brief has not been discussed, madam. The entire provision of the Panchayat Act has been discussed, but not that, particularly that, if your lordship will see. Now, for your lordships, in comparison, I have quoted the Assam Panchayat Act 1994 and the Schedule 10 of the Constitution, but your lordship see the wording. In the Schedule 10 of the Constitution on the right, such house, contrary to any direction issued by the political party to which he belongs. Whereas in the Assam Panchayat election, it is contrary to the respective political party. There is a difference. And in Tripura, I have that in the contrary to any direction. Below, I have quoted section 16 of the Tripura Panchayat Act, where it is said in the Gram Panchayat, contrary to any direction issued by the political party. If that were there, then you can say yes. You can't even vote for inter-party candidate.
Contrary to respective party means
Respective political party.
respective political party means if there are 2-3 political parties, and like if you are from Congress, then you will have to hear Congress. You are from BJP, you have to hear BJP.
Yeah.
So it's respective parties. It means. But thing is that
And in the 10th schedule, it has been issued any direction issued by the political party to which he belongs.
so that is more clear. Here it's not properly worded.
No, if the intention of the legislature was to have this concept of whip in this stream 1C, then they would have just cut copy paste the 10th schedule wording here. They have not deliberately not done it.
But
the party statement has said that you don't have the power to issue whip. This is not a statutory right. One cannot say that.
That's that document now the subsequent document.
Yes.
That he has brought in, that the party whip was in fact not authorized. So that's an issue. I mean that has to be dealt with. That's an issue that's an important issue, because only on the basis of this, whatever right you are getting to file this petition, you are getting that only because there was an instructions or whip, whatever. But now they are saying that like there is no authority to give it. So that is an issue, which has to be, dealt with.
Well, let the authority be decide. DC has to decide that. 111(3)C has to decide. Let him decide then. What inquiry, how it has to be decided, let him decide.
I think you should file an affidavit and bring
Yes,
this on the.
so I will just file a 2-page affidavit, we'll bring it.
We'll put up this matter on this thing.
We'll file it,
I mean,
on
next.
7th, your lordship can.
Then not that far, not that far.
Month ka chair, my lord, election, everyone is in this festival.
No, why I'm saying so, because Congress party is also there. Mr. HRS Chaudhary has also submitted. He has also made certain, I mean.
He is for the district, not for the state.
No, correct. So, I mean, now you are bringing in this document.
7th, your lordship can have it or after election.
I don't, I've not seen the inquiry report.
But
No,
yes,
inquiry report.
I'll file it in the form of affidavit.
So let
all these people.
No, let it be.
No,
How much time it will require?
this takes away the whole, I mean, your, claim of there was a whip.
Yes. There was a direction.
That is an unauthorized whip. So
Let's see what
unauthorized.
unauthorized, my lord. I don't, not seen that.
Let him have a look, Mr. Kumar. Give him a copy. You share a copy, no?
To independent niki. To kenno copy palio. Independent candidate. Independent. We don't get copy. Independent. I don't know who is arguing.
No, she's not independent.
No,
She
no,
is
I
the
don't.
better half.
He DC niki.
Na moi disu.
No, he took who no. DC niki to. To independent niki.
No, it Congress party.
Oh, independent. No, he is independent. Who has given me is independent.
No, he has not given it. I have given it.
No, but from him you got it. That's why I'm saying.
My wife, you have not seen it.
Nowadays,
Good in supply.
very difficult to say. Now there is a somersault being made by all the parties.
That's the problem.
Yes.
That is the problem.
But on 7th, we can ask, because they are all busy with this election campaign.
How much time it will require? It is small affidavit.
Small
Let us not
affidavit.
linger this case. No, no.
All that
That this way, that way, it will go. My lord,
we have to
let's.
call that person from Dhubri.
Because Mr. Das, this will
No,
be.
we'll see it. What is there? What is there?
This will have some impact.
We'll see it. What is there?
No, it says that like there, I mean, there was no authority.
We'll see.
7th to 12th of the election of Sube campaign of this first.
Last day, I don't think. Let it file. You file it.
Then
You
you'll
have to
also
file.
take it after Bihu.
No, not Bihu. Before Bihu. 7th.
7th of Bishop to 9th of Bishop to holiday. 9 is the last election, 10th is the
We'll
holiday.
fix it in 7, Mr. Das.
7. Let it be on 7.
Yeah.
The 7.
70 file an affidavit and bring it on record, then 7 will decide. What is to be.
Yes.
It's better to be decided before election. Those take one of them, they cannot declare till 9, 10.
7. 11, 7.
9, 10 is a
Then
holiday.
you write this petition, you write. First one is 4692.
এটা তো হয় আর কি অ্যাডভান্স এগুলো পারলোই না হতো কি অ্যাডভান্স লাগে একটু
Mr. B. Das, the learned senior counsel, assisted by Mr. K. Ahmed. Also had Mr. B. D. Kuang for the petitioner, right? B. D. Kuang, assisted by J. Kuang. In 4962, you are respondent number? 5, respondent number 5. And you respondent number 6, and Mr. D.K. Nath, the learned senior government advocate, for respondent number 7. 4, sorry, 4. 7 who was appearing, 7, Mr. HRS Chaudhary. Huh?
Yep.
HRS Chaudhary was arguing, no? HRS Chaudhary was there. So 7, right? HRS Chaudhary, assisted by I'm saying. In your petition,
4962, my lord. I cannot take it.
decision 4 is 4960, right? K. Chaudhary. The other petition you write, D. Das. K. Chaudhary. And 4617, D. Das. Market respondent. uh, the matter was substantially heard. However, at the later stage of the hearing, Mr. B.D. Kumar, the learned senior counsel, has produced a document dated 21/8/2025, which shows that then don't write like this. Produce a document dated 21/8/2025 issued by Assam Pradesh Congress Committee.
But we may also be allowed to bring this on record. We have just got a copy of this, madam.
Okay, issued by Assam Pradesh Congress Committee, which will have some kind of bearing, in the instant case, and therefore he prays that the same should be brought on record by way of an affidavit. He should be allowed to bring that by way of an affidavit. He further submits that the Constitution of Indian National Congress will be also relevant in the matter, and the same should be allowed to bring on record by way of an affidavit. It is directed that Mr. Kumar shall file an additional affidavit Kumar shall file an additional affidavit and bring those two documents on record. Let the matter be fixed on 7th of April. 7th of April.
This I have seen, my lord.
Which one?
Let him file it.
This one.
Let him not change, nobody should change it. See, highly confidential file. See, 2/8/2025, 2/8/2025, and the order to form a committee is on 21/8/2025. We'll give a reply, let him file it. Very good.
Let him bring on.
Let him file it, then we have got lot of reply. We don't want to name, my lord, our council, senior council, we is a political party. We are not into political party, that we'll give a reply to this. Very good, my lord, it has come into record. 21/8 and 2/8. Committee form and report is there. Highly placed file. Very nice.
They bring it on record.
Very nice.
Now we have also the Constitution of the Congress Committee.
Very good.
Which doesn't say anything about the, we will all bring it on record. This ought to have brought in on record.
No, why this court, I see why this court is allowing this is that, I mean, this will have some impact on the, because your case is based on that.
We'll give a reply to it.
The 7th we are fixing?
Yes.
7th we'll hear it out.
Hard and part, my lord.
Hard part.
Yes, no? I know.
Hospital. In I second.
Next case.
I'll just come in 5 minutes. 5 minutes, just 5 minutes. Immediately after the vacation. Mr. B. Das, senior counsel, also heard Mr. CCC. CCC appearing for the respondents. Submits that he has received the record and he requires some time to watch the
They have
accordingly.
They have filed the affidavit.
Only thing is the record in this.
Records to be required because when the inquiry
DP is there.
When the inquiry was conducted, they relied on the preliminary inquiry. No, that preliminary inquiry was never served to us. That's our case, and you cannot rely. There's a case. And second, the inquiry report, which was prepared and which was report was furnished, is by the disciplinary authority. So inquiry officer
and disciplinary
are two different. How can they pass? So they're making me compulsory retirement itself is bad. Inquiry report goes. That's our case.
Yes.
Yes. Let's say fixing a date.
Let them
After vacation, any can keep on it.
28th of April,
Yes, no problem.
28th April,
28.
28th. Let the matter fixed on 28th.
28, 28.
28.
Yes. Deeply office.
We'll file our affidavit. He said, my friend said the copy was not, so I will serve in lodging.
Okay. Heard
Maybe
Mrs.
second up
So-and-so,
next
the
week,
learned,
my lord.
learned counsel appearing for the petitioner, also heard Mr. S.S. Roy, the learned CGC. For the respondents, the learned CGC submits that he has filed an affidavit in the instant case of case, full stop. The learned counsel appearing for the petitioner submits that he is yet to receive the copy of the affidavit, full stop. A copy of the affidavit shall be served upon a copy of the affidavit shall be served upon the counsel for the petitioner during the course of the day. During the course of the later matter fixed after the ensuing BU vacation.
So can it be before that, my lord?
Before that will be difficult. Lot of
Recruitment
matters
process, my lord, petitioner, recruitment process, my lord. Already they have published the result, final result, my lord. So can it be, my lord, before any
Before
date?
BU it will be difficult.
Any date, my lord.
Immediately after the vacation, immediately.
On 21st we will take up, immediately after 21st of April.
Attempt maybe.
Let the matter be fixed on 21st of April. 21st of April.
Publishing.
Lordship, in this case, Lordship, on the last occasion, it was reflected 2 weeks time required for filing of affidavit. We have already filed in this case, Lordship.
You filed an affidavit?
Already filed. Let it become a.
You have received the copy?
Yeah, we have received.
You received the copy. You'll file reply?
I think reply may not be
May
required.
not be required.
Let it be on 21st, Lordship.
Okay.
It may be hard since
Mr.
affidavit has.
So the learned counsel appearing for the petitioner, petitioner, and also Mr. S.S. Roy, the learned PCC. Full stop. The learned CC submits that the affidavit in the instant case has already been filed. Accordingly, let the matter be fixed for admission hearing after the ensuing BU vacation. Interim order so passed earlier shall continue till the next date of listing.
21st not.
After the BU vacation.
No, similar matter. 17 is also
17 is also similar.
17, so that should be on 21.
We fix there on 21st.
Obliged.
21st of April. Similar means what? I mean, the two petitions, different
Two petitions, same advertisement, same post.
same advertisement. Okay.
Standing at a two.
The matter has come from mediation, Lordship.
Yes, we want to, will place it for mediation.
Yes, sir.
Yeah, Mr.
K. Mujumdar, Lordship.
K. Muzumdar, the learned counsel appearing for the petitioner. And who is, Mr. Datta is there? Who is there in this?
Two.
Elementary education. Anybody is appearing for elementary education? Anybody is there from education department? Now, is it, I mean, will any purpose will we serve this? None appeared for the respondents when the matter was called. However, the petitioner, the counsel appearing for the petitioner submits that matter may be sent to the mediation at mediation in view of the aforesaid. Let the matter be placed before the mediation center of mediation center of Gauhati High Court.
There was the interim order, Lordship.
Gauhati High Court, and the mediation center will accordingly be the need for placing the same before a selected before a nominated mediator, and endeavor shall be taken by the mediator to resolve the issue within a period of 2 months, and thereafter file a report of the mediation before this court. interim orders of passed earlier shall continue till the next date. But in interim orders, interim order is extended till the matter is resolved by the mediation. Because
Item 6.
mediation,
In this case, we will be filing wakalatnama for the petitioner, your lordship. The previous counsel, as per my information, has recused himself from the case.
should we send it for mediation? We have not filed in the wakalatnama.
Let us.
The issue may not settle in the mediation.
You will take down.
There-
Mr. Misra, the learned counsel, appearing for the petitioner submits that they will be, that he will be filing, he has instructions to appear in the matter and will be filing the wakalatnama soon. Full stop. Also heard Mr. A.K. Dapta, the learned CGC for the respondents. The parties, the counsel appearing for the parties submits that, that the issue involved in this matter may not be sent to the mediation as the same will not the purpose will not be fulfilled by sending it to the mediation. Accordingly, let the matter be listed for admission admission hearing in usual course. In usual course admission will.
I'm deeply obliged.
Item 8.
Take the I 97 of 2026. I have filed an IA. Anything of this interest of operating. Your Lordship, the
Yes, A&M nurse. What?
Yes, your Lordship. The issue is like this, your Lordship.
Yes.
Your Lordship, the interim order is of 16/12/2025, which was further extended on 21/1/2026. Your Lordship, petition has been filed by association ventilating the grievances. They are challenging the final gradation list of 3/2/2025.
Yes.
Wherein they are claiming that the members of their association names are not there. So before I proceed with my case on merits, I would like to raise my objection as regards the maintainability of this writ petition.
What is the objection?
Your Lordship, this writ petition, if your Lordship kindly take up the writ petition. This writ petition has been filed by the All Assam A&M and Challenges Service Association.
Yes.
The president and the secretary has shown the affidavit on behalf of the association. Now, the first ground of objection is that a writ petition cannot be filed by an association ventilating the grievances of the other members. In case of selection and promotion, there can be no grievances raised by the associations because no legal injury has been caused to them.
Yes.
Basically, there are no locals to file this writ petition. That's my basic argument.
But all the members are getting affected.
Your Lordship?
All the members are getting affected.
No, the members are getting affected, but they should have come in individually because there are only 14 numbers of members.
Why the association is ventilating the grievances?
Because they are part of the association. Association is ventilating the grievances of their members.
That their names are not there in the gradation list. That their names are not there in the gradation list. Your Lordship, I'll place few judgment puts. Your Lordship will kindly take the first judgment, 2022 SCC online Gauhati 1426. This is a division bench judgment.
Which one?
2026, 22 SCC.
2022
SCC online. I've read over the judgment.
4126.
Yes, Your Lordship. 1426.
1426, yes.
Your Lordship, this was a case where there was an advertisement by the Nagaland Judicial Service. And the Bar Association of the Nagaland filed a case ventilating the grievances, challenging the
Bar Association
of Nagaland.
Nagaland and ventilating the grievances of
That this against the select list. Against the select list for that some of the members could not get selected in that post.
Bar Association.
Yes, Your Lordship. Your Lordship will kindly come to para 6.
Bar Association file on behalf of whom?
On behalf of the other members. Because this post were judicial officers post, Your Lordship.
The Bar Association is a different thing altogether.
Yes, Your Lordship. That's an association, Your Lordship.
But there's an association, but that's a different thing. Bar Association.
Your Lordship will kindly come to para 6. That will clarify the thing. The writ petitioner in WPC number such and such, the High Court Bar Association, Kohima, had submitted a representation on 10/4/2019, addressed to the Chief Justice of Gauhati High Court, objecting to the select list dated 43/2019, on the ground that same had been issued in violation of the reservation policy of the state. The Secretary to the Government of Nagaland Justice and Law Department had also addressed a letter dated such and such, drawing the attention of the High Court. The opposite objection is a request to review the select list dated such. In the meantime, 3 writ petitions came to be filed before the Kohima bench of the High Court. I'll skip the remaining portion. Now, para 7, the impugned select list dated 43/2019 has been assailed by the petitioners primarily on 2 counts. Firstly, the select list violates the reservation policy of the Government of Nagaland. Secondly, since the rules of 2006 does not prescribe any cutoff mark for the written test as well as Viva voice test for the candidates to be selected, the prescription on the advertisement to such effect merely based on recommendation of the food court on the administrative side was impermissible in eye of law. Now, Lordship will come to para 12. Mr. S. Dr. Learned Counsel appearing for the respondent number 5, that is the selected candidates at serial number such and such, on the other hand has argued that the High Court Bar Association, Kohima, does not have any locus standi to maintain this writ petition and therefore the same is liable to be dismissed on such ground alone. In the above contest, Mr. Datta has relied on such and such judgment to argue that the High Court Bar Association cannot intervene to argue that the proceedings were the sole issue in the validity of a select list drawn up in the recruitment process. Contending that this client is not a party in other writ petition while the select list is under challenge. So an objection was raised and that was dealt with by the Honorable Court in para 31.
Yes.
In this case, although the petition appears to have been filed espousing the cause of the members, has your Lordship got it? In this case, although the petition appears to have been filed espousing the cause of the members, yet the petitioner in such and such being an association, obviously it cannot claim any right to be appointed against any of the vacancies advertised in such and such. Therefore, for all practical purposes, the writ petition is a PIL. In view of the law laid down in the decision referred to above, we are of the view that the select list dated such and such cannot be interfered with by this court at the instance of the petitioners association. Since no grievance of an association can be recognized by this court is a matter of nature. So, Your Lordship, here is a case, the ratio will be same, Your Lordship. Here is a case where the association has came forward stating that their members' names are not there in the gradation list. If their members' names are not there in the gradation list, particular XYZ person's names are not there, let them come because they have stated that their
association consists of 6,000, 7,000 members. So the particular persons who are affected because of their names being not there in the gradation list, they should have approached. That's precisely what this judgment has said, Your Lordship. This was a division bench judgment, Your Lordship. Para 31 is very clear on that issue. Your Lordship, the next judgment is 2021 4 JLR 36.
2000?
21 4 JLR 36. I have given a copy, Your Lordship. Para 2. That's the facts basically, Your Lordship. The grievance of the petitioner association. Has Your Lordship got it? The grievance of the petitioner association is with the office order dated such and such issued by the respondent number 3, by which the respondent number 4 had been provisionally appointed as general manager in the Assam such and such. The further prayer of the petitioner is to set aside the agenda papers dated such and such, by which the conditions of the appointment of the respondent number 4 set out in the impugn order dated such and such are sought to be modified. The sum and substance of the petitioner association's case is that state respondents are illegally trying to recruit respondent number 4 as general manager by way of absorption instead of directly recruiting him in terms of the employment notice dated such and such. The members of the petitioner association is made up of graduate engineers, now known as such and such. Then the facts has been stated, Your Lordship. Now Your Lordship will come to para 6. Learned counsels for the respondents, on the other hand, submits that the writ petition should be dismissed as the petitioner is an association made up of engineers, of which the respondent number 4 is also a member. The Lordship has rightly pointed out to me that the members are affected, so why they can't come? So this has been answered here, Your Lordship. They also submitted that the petitioner has no locus standi to file a writ petition, as no legal or fundamental right of the petitioner association has been violated. Further, no individual aggrieved person has put to challenge the appointment of respondent number 4 as the general manager of such and such. They also submit that while the respondent number 4 was appointed, the petitioners association has filed this present case belatedly on 12/5/2020. Your Lordship will kindly note this belatedly. I'll advance my further arguments on this point also. Now, para 13. This is the finding of the court. It is also seen that no individual person has made any challenge to the office order appointing the respondent number 4 as the general manager. No person has also made any challenge to the APTCL sending the respondent number 4 to the such and such as general manager on deputation to attempt to absorb the respondent number 4 as such and such, as alleged by the petitioner. It is also seen that during the pendency of the writ petition, the respondent number 4 has been given pro forma promotion to the post of such and such, which has not been challenged by any person. In the case of Debojit Das and others, the state of Assam, the counsel for the petitioner therein has taken the stand that an association has no locus standi to challenge a promotion order, as an association is not an aggrieved person, and as it could not raise service-related grievances to of individual officers. An appeal was preferred by the division bench before the division bench in the case of Debojit Das, answered in negative. The following preposition with regard to the issue involved, the single bench, whether an association has a locus standi to challenge the promotion order of the officers. Paragraph 18.4 of the judgment passed to the division bench is reproduced here. Whether the association has any locus standi in the matter, the question is answered in negative. The matter went up to the Supreme Court in Ajit Kumar Bhuiya and others, wherein the said proposition and answers given by the division bench was not disturbed by the apex court. I'll place that judgment also, Lordship. In the case of Srinivas Reddy versus Karnataka Urban Association, such and such, the apex court has held that a court cannot sit in judgment over his wisdom of the government in the choice of the persons to be appointed, so long as the person possesses prescribed qualification and is otherwise eligible for promotion. In the case of Aarti Jain versus Union of India, the apex court has held in service jurisprudence, it is settled law that it is for the aggrieved person, that is non-appointee, to assail the legality or correctness of the action, and the third party has no locus standi to canvass the legality of the correction of the action. In the case of Ayub Khan, Noor Khan, Pathan versus State of Maharashtra and others, it is discussed. It is settled legal proposition that the stranger cannot be permitted to meddle in the proceeding.
So basically, it says that association cannot.
Cannot challenge your lordship. And finally, the finding that is at para 18. Fifth line from below. It cannot be said, has your lordship got it? It cannot be said that any legal right of the petitioner association has been violated if the respondent number 4 is appointed directly or absorbed in the post of such and such. This court is of the view that the petitioner association cannot be said to be an aggrieved person.
Yes.
And your lordship, there are others to judgment. I don't want to disturb your lordship.
On the similar issue.
That 2019 case, the Devojit Das case, which went up to the
Ajit
Supreme
Kumar
Court.
Bhuiya,
That one point, I'll just like to show one point in Devojit Das, page 279. That is 2019 12 SCC 275.
Para.
Para 12 down below 279. The question is answered in affirmative. Roman 4.
Para 12.
Yes, your lordship. Para 12 down below, Roman 4. Whether the association has any locus standi in the matter, the question is answered in negative. So on maintainability, if your lordship is satisfied, then I am not here to advance my argument any further to the on merits. I will not consume the court's time on that. Otherwise, also on merits, if your lordship is
I mean, since you are, arguing on the maintainability, let's hear them. Let's see what the response are. Then if the court is prima facie satisfied, then we'll take a decision.
I'll advance my call. I'll advance my arguments on the merits also.
My lord.
On the maintainability.
My lord. So far my petition is concerned. It is my learned friend who has encouraged me to file this petition. I followed him. It is my learned friend's steps I have followed, my petitioners. How? Why I have come before this court? Please come to page number 23.
No, I mean, that is that may be a different.
No, that is relevant. The page number 43. There's some reason behind it.
43.
Yes.
43 is which petition?
Of my writ petition.
Writ.
Yes. WBC 6016.
Page?
Page 43.
43.
Yes. Lordship has got it, my lord.
So he has filed list or what?
And I'm just showing my lord. Please see the name of the party.
Correct.
Page 43. All Assam Graduate Nurses Association are us. My lord, now your lordship may please come to.
Junu, who is Junu Das? Junu Sharma? Junu Sharma is.
She was the president of the association.
So you filed and you ventilated the grievances.
My lord, please. No, let me finish. I said I am following him. That's it. Yesterday. Please come to page number 50.
Nobody pointed out that those things when he was arguing.
But now this is a system we follow, my lord. Once he finishes, I will start. I finish, then you will start. That's what we follow. We don't quarrel, never quarrel in the court.
Yes. I mean, yes, you have told me this.
Page 50, my lord. Please come to paragraph 7.
Paragraph 7.
Yes, let me read. Learned senior counsel. In this case, my lord, senior counsel was Mr. Justin Nair, and my junior counsel was my lord, my learned friend.
Yes.
Learned senior counsel, by referring to 1991 rules, more specifically rule 22, this is the issue in my case also here today, has submitted that condition precedent of having the gradation list has been admittedly violated, which is apparent from the period case of the respondent department by referring to the affidavit in opposition dated such and such filed by Mr. Das has submitted that in paragraph 9 thereof, there's a clear admission that two gradation lists were prepared. One gradation list consisting of the nurses personnel serving in the academic side and the other consisting of nurse personnel serving in the clinic admin side. It has further been submitted that pleadings of the affidavit in opposition are wholly inconsistent. My Lord, Lordship may skip this paragraph. Lordship may please come to paragraph 11, my Lord. 11, bottom. The issue is not with regard to having the eligibility to be promoted to the next higher post of assistant matron, assistant nursing superintendent, deputy superintendent, such and such. But principal conditions which were required to be followed before initiating such promotional exercise, it is admitted fact that two gradation lists are prepared instead of one contemplated by section rule 22 of 91 rules. And it is from the gradation list of ward sisters alone that the candidates were considered and promoted to the 71 such vacancies, my lord. Now, Lordship may please come to paragraph 12. Senior counsel for the petitioner's minutes meeting dated is not consistent with the period case the respondent has found such and such, my lord. Next, paragraph 13, operative part. In view of the above fact circumstances, this court does not have any other option but to interfere with the impugned exercise, which culminated in the impugned order dated 11/4/18. Accordingly, the entire promotional exercise pertaining to assistant matron, assistant nursing superintendent, deputy superintendent nursing undertaken on the basis of the two gradation lists, culminating in the order dated 18/4/18, is interfered with and set aside. Department may carry out a fresh promotion exercise by strictly adhering to the provisions of 91 Act. At this stage, it is observed that since private respondents who are beneficiary of the faulty promotional exercise and are serving in a higher post, no recovery should be made from them. The same direction would also be applicable to those private respondents who have retired on superannuation in the meantime. A fresh promotional exercise may be carried out and completed within time-bound frame, preferably within 6 months from the date of receipt of the certificate copy of the order. It is further observed that since there was the need for promotion to the next higher post of assistant matron such and such, the fresh exercise promotion would be given national benefit from the date of such and such. This is the case where what has happened? Rule 22 says
one list.
One list.
They made two lists.
They made two lists.
Correct.
Association came. They said you have made two gradation lists wrongly. That is in violation of the Rule 22. So whatever promotion has been made in terms of those, set aside these two gradation lists and also is set aside the promotion of those persons. Those have been already promoted. So they have been brought down, my lord. But salary is not deducted. Rafiq Mashi case, my lord, lordship knows. Once they've worked, my lord, that's the reason. Now, in that case, what they've done, they've challenged that gradation list and the promotion already made.
No, correct. Now see, I mean, now he's raising some preliminary issues. He has shown some Supreme Court judgments also. Though he was there in the case.
Yes.
Now, thing is that issue was not pointed out before the court at that point of time, so court did not consider it. Now, what is your submission on that? That will be relevant.
If I say, my lord, that
only because somebody has filed it some time back, and they got a benefit out of that, and nobody has.
No, that went to the division bench also. The division bench didn't stop that point.
Correct. I mean that issue was not raised.
That's the one point.
That was not raised.
That's one point.
Now the issue has been raised. The court has to consider that, and the court has to give a finding on that. Now, what will be your answer to that?
My answer will be, my lord. First of all, two things are there. One is
he has cited some case laws. So you'll have to distinguish those case laws, or you'll have to say
but so far those case laws, my lord,
case laws are not applicable to this.
My lord, right? The moment he has raised the case of today, on earlier day he didn't raise these issues, my lord. So once he has raised these issues and the case laws, my lord, at least let me go through it and I return, my lord. Lordship may fix the date on that. That is one of the ways of looking into it, because he has placed the case law. Now, all of a sudden, if he make my submissions, it may not be correct for lordship to adjudicate the matter also properly, my lord. So if your lordship is fixed like Monday to Tuesday, I get 1 evening, 2 evenings. There you will not say no, I know, my lord.
So when the stay was given, you were there?
No,
they are imputed party.
No, we got ourselves implemented, your lordship. In fact, that is also one of the.
But you argue here, this side, when it is beneficial, this side, you argue that in
that is no, it is not like that. Let me fairly submit.
There's another case. There's another case.
Fairly submit, your lordship. In that case, the issue was totally different. And although we
Now, what was the different issue there?
Your Lordship, the issue was with relating to the making of a gradation list. There was two gradation lists. We ventilated only one thing. We didn't challenge that our name should not be in the gradation list. We said that there should be one common gradation list. We didn't say that please include us
No,
in
no,
the
that is
gradation
not the question. Question is whether you could have filed filed the writ petition. That is the thing.
Yes, Your Lordship, we could have filed it.
Then why, why not in this case?
No, in this case, Your Lordship, they are claiming that the names of the members are not there.
Now, out there also the association is, I see, grievance of the association is same almost. Grievance is that like something which has not been done in a proper manner,
But Your Lordship, the point is
in a legal manner.
But
Now since you have cited these cases, so he has to answer it. That's a different thing. But in that case, you got relief. Because you filed that.
Your Lordship, the relief was to the extent that there will be one gradation list, not two gradation lists.
No, it's
and all
not.
those persons who promotions
It's
were
not
challenged,
about
they got the
it's not about on the merit. I'm talking about the maintainability.
But
And how those things to do? Is it like different situations? Different cause of actions?
Your Lordship, my friend was also there. Sorry, Mr. D.P. Bora was there. Your Lordship, situations are different. That I can address Your Lordship on that issue. But anyway.
No, that will not going to harm your case.
Yes, Your Lordship.
I'm not saying that will demerit your case. I'm just asking you.
That's the beginning I said. I'm following him, my lord.
In
The
that
beginning
issue,
I
Your
said.
Lordship, nobody has raised the maintainability issue. Including
No, that is what I'm asking you.
Yes,
You don't need to.
But right
He
now,
got
I'm
the
raising
cream,
it.
my lord. He got the cream. And the packet he's
Now,
throwing at
right
me.
now, I'm raising it, Your Lordship. Otherwise, I'm also raising it on
No,
merits.
this is good. The court is appreciating that. He's raising it when it needs to be raised.
Yes,
If somebody did not raise it, what he can do?
Yes, that's true.
In fact, otherwise also, Your Lordship, this petition is liable to be dismissed on the ground of delay and laches.
Okay, let him go through this. Then we'll hear it on some other day.
I'll give him a soft copy.
Mr.
There's the beauty, my lord, of this court, my
Nath, the learned senior counsel. Senior counsel, assisted by also have Mr. R. Sinha. He's for the applicant, huh? R. Sinha, applicant for so and so. He's responding. Mr. Gogo is appearing. Mr. B. Gogo, additional advocate general appearing for the health department. When do you want it?
First, my lord. Wednesday.
Yes, Your Lordship.
If it is not inconvenient, your lordship.
Your Lordship has heard it.
No, we will not fix. We have not heard it. We'll fix it on first. If the bench is there, we'll hear it.
Okay, Your Lordship.
Let the matter be fixed on first of April.
Your Lordship will record that submission as regards the maintenance.
No, we will write it. Mr. R. Sinha, while arguing the IA, has raised the issue of maintainability of the in support of his submissions. He has placed certain case laws. Full stop. Mr. Nath, the London Senior Counsel, submits that he needs to go through the case laws and require some time for that. उसको बाद में लिख देना in view of the aforesaid the case is fixed on first of April. उसको मिला के देना. Okay, we'll first of April.
Your Lordship, let the judgment remain.
No, the data judgments remain.
Your Lordship.
I don't know.
May I please the lordship? Earlier,
Before you start, I heard there is some matter going on in the division bench regarding, applicability of that case that you have cited. Huh?
Another judgment has been by Prohibitions lordship, which was against which lordship one appeal was preferred before the division bench. And the court dismissed that appeal lordship. Upholding the judgment.
Coordinate bench. Coordinate bench has given what judgment given?
Pass an order. It clearly distinguished Dharam Singh, etc. And the court said that in view of the order passed by the Umadibi, High Court cannot pass any order directing regularization of service of the member.
Okay. Let me see which is it.
Before he submitting the judgment, my lord, I want to say Uma Devi supported my case. Some document, my lord, I could not get, my lord. Subsequently, I got hold of the document, my lord. My appointment is a regular appointment, my lord, but service of the was not.
But those documents are not on record.
That document, earlier I was not getting document. I filed an additional affidavit.
When did you file it?
Yes, my lord. I filed the additional affidavit long back, my lord.
So you have filed it earlier. I mean, before before the matter was heard. Last time when
I got the document, I filed this additional affidavit, my lord.
no, when the matter was heard, at the time it was there.
At that time, not there, my subsequently filed. If your lordship got that document, my lord, that fact should be bring before the court, my lord. Additional affidavit for having here. Lordship, kindly come one point, my lord, first.
No, one second. Additional affidavit
filed by me, my lord.
Okay, let me see.
It was filed on, my lord.
Filed on 9/2.
Yes, my lord.
9/2/2026.
Yes, my lord.
Yes.
Your lordship, kindly come to the, my lord, page 33 of my appointment letter. Important, my lord.
Page 33, the initial appointment.
My initial appointment, my
One
lord.
second.
Page 33, C1. In pursuance of government letter number.
Page 30,
Page 33.
33.
Yes, my lord. In pursuance of government letter number SYW dot 136 2012 /18. That is important, my lord. I was appointed. Then last part of the order, my lord, may come, my lord. The pay may be drawn from the head of the account of so and so, other non-plan scheme, direction, administration ways, and during 2013-14. Have a lordship look it?
Yes.
Then your lordship come to the my additional affidavit, page 126. Economy office no process.
Yes.
Lordship, kindly look to the that, my lord.
126.
126 Annexer L.
Yes.
To GD Laskar, Deputy Secretary to Government of Assam, number SYW 136 /2012 /18. Have you lordship got it?
1,000. Type copy is there, no?
Yes, my type copy is there. 126, my lord.
124 is the type copy.
Yes, my lord.
Yes.
Yes, my dear, copy.
The creation of a post.
Yes, my lord. I am reading that, my lord, because, my lord, if your lordship go to the, my lord, that 126L, my lord, I read original part, my lord. I put myself.
It cannot be read.
This is your lordship, I'll go to this one.
No, this is there. I mean, type copy is something wrong is there.
Type copy typing who consider. One is typical mistake, my lord.
Okay, read.
136, my lord.
No, from 126 you read.
136, my lord, sorry. Number SYW 136. Letter number. Top part, my lord. Have you looked at it? Letter number
136. Yeah, here you have written 130.
Yes, my lord.
Okay, 136 201
2012
18.
18. Dated
14/3/2013. 2013.
Your lordship kindly look that. Because on the basis of that, the post has been created and I was appointed. May I read the whole letter, my lord?
Yeah, you read.
To form GD Laskar, ACS Deputy Secretary to the Government of Assam Sports and Youth Welfare Department, to the Director of Sports and Youth Welfare. Creation of post for the Director of Sports and Youth Welfare Assam. Your letter number so and so, dated 29/12/20. With reference to the letter quoted above on subject, I am directed to inform you the department have no objection to the filling of newly created post list enclosed during current financial year. After observing all required formality as per approval, according to the finance department by dear so and so.
Where is the list?
My lord, that list is not available. I am reading, my lord. My part is come last, my lord. Further, in respect of other posts proposed for creation of such senior assistant, as per list enclosed, it appeared that there are sufficient job. Such posts already office. Sports and welfare is advised to train existing junior assistant, enable them in computer instead of creation. Last line. This is my part, my lord. As regard the post of sweeper, director of sports and welfare is advised to engage sweeper on wage basis at fixed pay. So my humble submission before your lordship, my appointment is not illegal appointment. He has said, and
No. I mean, you said that you have been appointed regularly. Where?
Regularly, no, my lord. My appointment is, my lord, daily wages basis. But after going through this letter, he has said the director has appointed some person like that, my lord. After going through the letter, I was appointed in the service. That is my appointment may be said irregular appointment, but not illegal appointment. I want to say that pardonably.
Okay.
Yes, my lord. Now, my lord, what Uma Devi said, pair 52, my lord.
No, now see, now he is saying that a similar matter has been disposed of by coordinate bench and which has been already dismissed by the division bench.
Kindly give me the copy.
Share one.
Yes, my lord. And also
Mr. Nayak, give him one copy.
Orissa key facts as a sound other.
Here at least 5 reasons have been given why no order for regularization can be passed on. Also, can you see the player 2, paragraph number 2?
My humble submission before your lordship is there. If Uma Devi supported my case, my lord, then my lord, he cannot say, my lord, what passing.
No, Mr. Chaudhary.
Yes, ma'am.
Now, if a coordinate bench has passed an order and which has gone to appeal has been dismissed.
Yes,
Appeal has been dismissed in a similar point, then I think you should go through this case and come up. I mean, otherwise,
Yes, my lord. Yes, my lord.
What will you argue?
Yes,
and if it is already
provided me the copy, my lord.
He will provide you a copy.
Copy na lage number kita da. Dia ite dia.
You can take this thing.
And what is the order of division bench?
You find it out, Mr. Chaudhary.
I shall go.
You go through it and we'll fix it up tomorrow. Tomorrow or when?
Not tomorrow.
When?
And
it is remaining part hard, that's why.
Yes.
Okay, we'll fix it on sometime on
29th.
Hey, ban deri ke order. You could 21.
23rd, Mr. Nayak, 23rd.
23rd is possible.
Yes, ma'am.
On the prayer of the parties, let the matter be fixed to 29th of April. NNB Chaudhary and Mr. Nayak, additional advocate general.
Lordship, I have a small pair. Kindly give the provide the number of the case of the division bench.
Mr. Nayak, if you have it, you give it to him.
You can just right now. 78 or 26. Very difficult.
He is not as resourceful as you. You give the number.
78
of 20.
78 of 26.
Carried is the
Petition.
We find it out. You are a resourceful person.
Good petition. Must oblige.
Okay, we'll hear it on.
Admission.
Worship, in this matter, we have filed our affidavit and for BTC matter. And yesterday we have filed our affidavit, but it is not on record. So. Have you received?
We have received. Lordship, we seek time to file a reply to this affidavit.
I have got a copy of it from the BTC. And I also need some time.
You will also file an affidavit. No, you are appearing for whom?
On the state of.
State of Assam.
Our affidavit is already there.
Hmm.
TCS filed it, I got the copy today.
Okay. Heard, Mr. Your name?
Chand. Chand.
And the Planning Council for the petitioner also heard.
B. Bora for BTC.
BBR for BTC and DK Nath, learned senior government advocate for the state of Assam. You are also appearing?
Yes, Lordship for timely respondent number 2.
Student number 2. Just Chutia, you are there? Oh, he's appearing. Okay. Okay. Ms. So submits that she has filed an affidavit in opposition in the instant case yesterday. However, the same is not on record. The petitioner has, the counsel appearing for the petitioner has also sought for some time to reply to the affidavit in opposition filed by the BTC. Mr. DK Nath, the senior government advocate, house prays for some time to go through the affidavit filed by the BTC. You are not filing anything, but you just need to go through it, right?
If necessary, because I don't understand the BTC.
Go through it, and if required, he will also file an affidavit in view of the aforesaid. Let the matter fix after the BU vacation.
After the
ensuing BU.
or in the month of first week of May.
Okay, first week of May. First week of May.
Obliged, Lordship.
First week of May.
46.
Your Honor. Lordship, I am appearing on behalf of the petitioner. The matter may send for before the mediations.
It has come for sending to mediation or what? What is the issue?
It's regarding the family pension. Yes, what has happened?
So it can be resolved in mediation.
Yes, yes, Lordship, and the computer perhaps Lordship was identified for reference to mediation, Lordship. And once it was listed under that column also.
Then what happened? It was not sent.
No, on that day, Lordship, the counsel from the pensioner side.
Okay. Can you write heard MS so-and-so, the learned counsel for the petitioner? Also heard Mr. So-and-so, the learned counsel. You are appearing for respondent number?
7, my lord. 7.
7. And Mr. A Neuk for?
1, 6.
1, 2, and 3. The counsel appearing for respective parties submit that the matter can be resolved in a mediation process, and therefore praise that the matter should be listed. Matter should be sent for mediation. Full stop. The court has gone through the issue involved here and is of the opinion that an attempt for resolving the issue can be made before the mediation center of Gauhati High Court. Full stop. In view of the efforts, accordingly, let the matter be listed before the mediation center, Gauhati High Court. Full stop. The mediation center, thereafter the mediation center will nominate stroke engage a mediator to resolve the issue. Full stop. The mediator shall take all the endeavors to resolve the issue within a period of 2 months, and thereafter submit the report of the result of the mediation. Full stop.
47.
My lord, in this case, my lord, the respondents, they have yesterday served us a copy of the affidavit in opposition, my lord. Today they have filed an affidavit in opposition, my lord. I pray, my lord, we may be allowed to file a reply, my lord. A date may be fixed, my lord, after the Bihu vacations, my lord.
Heard Mr. Count, the learned counsel appearing for the petitioner, also heard Ardev, the learned counsel appearing for
On behalf of
SS Roy, the learned CGC. Full stop. MS Dave submits that he has filed an affidavit in opposition today only. Full stop. The same is not on record. Next slide, same is not on record. Mr. Khan submits that he would like to file a reply to the affidavit of opposition filed by the CGC. Therefore, praise for 2 weeks' time. Prayer is allowed. Let the matter be listed after the ensuing BU vacation.
Interim may be extended. There's an interim order which was passed.
Interim order so passed earlier shall continue till the next against.
I pray for fixing a date after the BU vacation. After the BU vacation.
In the month of May, let the matter be fixed on 7th of May.
Much obliged.
Okay.
90 billion.
May I please, your lordship? My lord, regular bail application, the petitioner is behind bars for 3 months and 11.
Matter. I mean,
Yes, ma'am.
no notices. Huh?
Amicus
Amicus is there.
appointed, my lord, and he has appeared. Copy has already been served, my lord. The petitioner is behind bars for 3 months and 11 days, my lord.
Huh?
3 months and 11 days, my lord.
3 months and 11 days.
11 days, my lord. Moreover, my lord, charge sheet has been filed and the trial is yet to start, my lord. Summons has been issued to the witnesses, my lord, and 33 is fixed for evidence. None have been examined, my lord, till date, and 7 numbers of PWs are there as per charge sheet, my lord. And in this case, my lord, 36(3) has been issued, my lord, arrest memo, where no signature of independent witnesses are to be found, my lord. Page 28 of the petition, my lord. 29 is the certified copy, my lord.
This is a new matter or what?
Actually, my lord, earlier anticipatory bail application was filed before your lordship. And the
That was
matter-
rejected. Where is that?
Not rejected, my lord. That was withdrawn, my lord.
Withdrawn.
Thereafter, he surrendered.
Have you made any statement on that?
My lord, we got the information subsequently after filing of this petition, my lord. That petition was filed by other counsel, my lord. We were not aware, my lord. So we got the information later, my lord.
What information?
That the AB was withdrawn, my lord.
Then you should have.
In second bail application, I believe.
No, my lord, that was not rejected, my lord. That was withdrawn, my lord. And subsequently, he was arrested and a bail application was filed before the trial court, my lord. That was
No,
rejected.
but his statement should be there. I mean, all deceive. I mean, now Supreme Court has said all the details about earlier bail applications, whether it's withdrawn, rejected, or considered, not considered, doesn't matter.
Yes,
You should make those statements here.
Yes, my lord.
Your statements are not there.
Yes, my lord.
It's
Actually, my lord,
incomplete.
that happened, my lord, due to, my lord, we were unaware about the fact, my lord. We came to know after filing of the petition, my lord. That is why, my lord, I have stated, my lord.
And what is the ground you are taking?
Lord, 36(3) is violated, my lord. Moreover, my lord, signature of witness is not there, my lord. Page 29 is the certified copy, my lord. Moreover, my lord, in the medical, my lord, no sign of.
I will issue notice on this.
My lord, notice has already been issued, my lord.
Oh, so
Amicus
he's
is
already there.
appointed.
He's already there.
CR has already been received, my lord.
But earlier order is required because on but on if that order has earlier electric
withdrawn.
File an additional affidavit. Bring that on record. No, yeah, day before yesterday also same order was passed when it was not mentioned here.
Then, my lord, a short date may kindly be given.
I mean, short date, I mean, it will depend.
Otherwise,
You file an additional affidavit.
3 months, 11
Heard
days.
Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. Mr. K. Vishwa, the learned EPS law court, the learned APP for the state, as well as DAS for the as DAS, the amicus query for respondent number 2. It is seen that it is seen from the records that though an anticipatory bail application was submitted by the accused applicant, which was later on withdrawn. No statement about the order or filing about the application or filing of about the application and order passed by this court has been have been stated specifically in the in the instant bail application. And no order is also annexed in the application. In view of the aforesaid, the learned counsel appearing for the petition accused applicant submits that he would like to file an additional affidavit, bringing on record the aforesaid order, aforesaid order, full stop. In the let the matter be listed on when.
My lord, Monday, my lord. I'll file by tomorrow, my lord.
Monday is what date?
23.
31st, you will fix it on 31st. Let the matter be fixed on 31st.
My lord, 31st will be, my lord, too long.
See, don't keep on insisting when a date has been given. We have given a short date only. Today is what date? Today is what date? Today is what?
26, my lord.
26. When the date is given?
All right, my lord.
31st. 5 days has been in between. There is a weekend also.
Okay, my lord.
What more you want?
Oblige,
My pleasure.
Yes, Mr. Karim.
Earlier rejection order page number 29, Your Lordship. That was rejected on 14 November of 2025, Your Lordship.
Yes.
Thereafter, Lordship, 3 independent witness, Your Lordship, including the Caesar witness, already examined, Your Lordship. That's page number.
What was
24,
the
Your
quantity
Lordship.
commercial? Quantity commercial quantity.
22C, Your Lordship. Page number 24, Your Lordship.
Now what is the stage?
Evidence stage, Your Lordship. Already independent witness and Caesar witness already examined, Your Lordship. Others are official witness, Your Lordship. Annexure D1, Your Lordship. Kindly see page number 24, Your Lordship.
But it's very difficult, Mr. Karim.
Lordship, all 3 evidences are hostile, Your Lordship.
Still, it will be difficult. It will be difficult. Your ground is only thing is that
Yes,
how many days?
Total 267 days, Your Lordship. 8 months, 24 days, Your Lordship.
267 days.
Lordship, 267 days.
Huh?
267.
267. That's what I'm saying. 267 days.
Lordship.
And how many witnesses were there? 12.
Lordship.
And out of that, 3 examined.
8 members.
Huh? 3 examined.
8 numbers. 8 numbers, Your Lordship.
12 or 8? Confirm.
Page number 19, Your Lordship. There is a charge sheet.
Where is the charge sheet?
Page 19 is relevant portion, Your Lordship.
Page 19?
Lordship. Page 16 is start. Page 19 is relevant portion. 8, Lordship.
8.
Here, Sabir Khan, independent PW1, Mominur Sheikh, PW2, and Islam Jabedurias, PW3. Others are independent.
Difficult, Mr. Difficult.
Long vaccination, prolonged vaccination, long list of witnesses, all these are sustainable in the case of any offenses in case of cannabis and other lordship. And apart from that, lordship, it is not like that lordship, only the Caesar witness, only on the basis of Caesar witnesses or the independent witnesses, the conviction can be given. There are some other instances.
311 grams, Your Lordship, articles. 311 grams only.
See what Supreme Court has said. We are of the view that I'll read the other paragraph also. Over a period of time, we have noticed 2 things. Either bail is granted after charge is framed and just before the victim is to be examined by the prosecution before the court, or bail is granted once recording of oral evidence of the victim is complete by looking into some discrepancies here or there in deposition and thereby testing the credibility of the victim. We are of the view that aforesaid is not correct practice that the courts below should adopt. Once trial commences, it should be allowed to reach to its final conclusion, which may either result in conviction of the accused or acquittal of the accused. Supreme Court is saying that once trial starts in this kind of offenses where murder, rape, or NDPS matters, it should be allowed to go on. Provided, I mean, if there is a long incursion, 6-7 years, it is not happening, that's a different issue altogether. But this is the approach Supreme Court has stated to be taken by the trial court as well as the High Court. So we are bound by that.
Lordship, here the petitioner is a local person, Your Lordship.
He is a local person
at
or
the-
he's a foreigner,
some
doesn't
of the
matter. We
police station,
heard
Your
Mr.
Lordship.
A. Karim, we'll pass the order. We'll
Lordship,
pass the
I
order, no
prefer
time now.
fix
We'll
the
pass the
date after review, Your Lordship.
No. Why should we keep it pending? We have made up our mind.
The next date is fixed on 13th, Lordship, 30 March,
No,
Your
you
Lordship.
go-
There is evidence, Lordship.
If you want to withdraw it, withdraw it. If you want to withdraw it, otherwise I'm going to dismiss it. There is no ground.
And
It's up to you.
fixed for evidence, Your Lordship.
Correct. You go and appear. Who is stopping you?
No, I am already in the custody, Your Lordship.
Oh, correct. You appear. I mean, appear means I'm not saying that you will be released and go and appear. You attend, maybe, I mean, the trial will be going on.
In case, Your Lordship, there is no chance of option, Your Lordship. He will regularly appear, Your Lordship.
No bail,
on
no
any
bail, no
condition,
bail
Your
at this
Lordship.
stage. No bail at this stage.
And there is no chance of
No bail at this stage, see, no bail at this
conviction,
stage.
Your Lordship.
No bail at this stage. No chance of conviction, that will be decided by the trial court. We are not going to appreciate the evidence now.
And this three evidence already hostile, Your Lordship.
I'm not going to appreciate anything now. What I'm saying is the trial has started. It is going reasonably good speed. Not much days we have spent before this. It is that section 37 is already there, NDPS, commercial quantity, you will not get any benefit out of that. So we will dismiss this.
Withdraw kindly.
If you want to withdraw, then withdraw it. That's up to you. Withdraw.
Withdraw.
Heard Mr. A. Karim, the learned counsel, appearing for the accused applicant. Also heard Mr. P.S. Locker, the learned APP for the state. Full stop. Mr. A. Karim, the learned counsel, submits that he wishes to withdraw the instant bail application. Full stop. Prayer is allowed. The matter is dismissed and on withdrawal.
Oblige, Your Lordship.
23 and 24.
I took some time to advise your lordship about the status of our review file.
Yes, what has happened to them?
The status, I have updated yesterday, it shows it is pending.
Pending.
It's pending.
So what will happen?
But I prefer some time. Let me let the review petition be considered by the apex court.
Hmm?
I have undergone this yesterday, my lord. Status is shown pending, my lord.
It is pending. What is to be done? You will have to wait for some time.
What will be my minute?
Okay, heard Mr. Your name?
P. Deka.
P. Deka, the learned counsel appearing for the petitioner. Also heard Mr. D.K. Nath, Mr. D. Nath, the learned. You are appearing as
Yes, this is a contract. I complete respondent.
as a counsel, not as
Yes.
Mr. D. Nath, the learned counsel appearing for respondent number.
Both.
Appearing for the respondents. Full stop. Mr. D. Nath submits that a review petition filed against the judgment and order dated. 26 or what? 26.
Yes, ma'am.
26/2022.
Yes, ma'am.
A review petition on what? That single bench is it has gone to division bench.
Single bench, we went to RTP.
Hmm.
RTP was dismissed on 18 to 2025.
So against that you have gone, no?
We filed SLP. SLP got dismissed.
Correct.
Against the dismissal of the SLP, we have filed a petition.
Okay, then we will not record so many things. So you will record the review is pending.
Yes.
A review before the Supreme Court is pending, which will have impact in the instant case. Therefore, he prays for some more time so that the matter so that the matter can be heard by the Supreme Court. Full stop. In view of the aforesaid, let the matter be listed. How much time?
Let it after 4 weeks.
4 weeks.
No.
Let the matter be fixed after 4 weeks.
No. Problem.
Of the instruction.
As per my
Have you
instruction,
closed this?
no, Lordship.
Why?
Lordship, we have not been able to finalize the pension yet. Lordship, here, the GIS amount is amount to be paid within 1 week. For the leave admissibility report, Lordship, we need the approval of the AG. And for pension, Lordship, my department has fought for some time for finalization, Lordship. Lordship, if we're given a date after the meeting, in the meantime, Lordship, I think we'll be able to substantially comply with the court's order.
Substantially means?
Lordship, because there was a direction to regularize the gap period of the petitioner that has been done already. And to give pensionary benefits, Lordship.
So gap period you have already done.
Yes, that period is now, since that is done, now we have been able to initiate the finalization of pension also because of that, Lordship. And for the other pensionary benefits, these two amounts will be paid within shortly, Lordship, hopefully before the next date. The leave leave encashment benefits and GIS emoluments.
Not Mr. So the learned counsel appearing for the petitioner, also heard Mr. H. Eliha, the learned counsel appearing for the respondents.
Yes, both the
Both the respondents, full stop. Mr. Chaliha submits that in terms of the order it is 63226, the respondent authorities has taken up the matter and already has stated that the respondent authorities have already received the proposals for sanction of group insurance scheme and leave encashment benefit in respect of the petitioner from the director of Ayush on 25/3/2026. By 2026, right? And the proposals are presently under process in the department. He further submits that as far as GIS is concerned, the fund is expected to be sanctioned within 1 week.
Yes, it can be paid
Within a 1 week, and the same can be cleared to him shortly, within a short time, can be cleared to him within a short time. As far as pensionary benefit is concerned, what about leave encashment?
Lordship, here, once the AG, the LAR is required from the AG, once that is received, Lordship, within 1 week, that can be paid also. So
He further submits that as far as leave admissibility report, and as far as leave encashment benefit is concerned, and that the leave admissibility report has to be obtained from the Office of Accountant General. Once the same is received, the money can be disbursed, full stop. However, as far as pensionary benefits are concerned, he submits that some more time will be required and prays for some more time, full stop. In view of the aforesaid submissions, let the matter be listed after the ensuing view vacation.
yes, Lordship, last week of April, Lordship.
Let the matter be fixed in the last week of April. Full stop. The learned counsel, for the respondents has submitted a communication dated 25/3/2026, issued by the Joint Secretary, Government of Assam, Medical Education Research Department, as a basis of his submissions before this court. The same is kept on record, marking X. Let the matter be listed. It's last week of April.
Happy with Lordship.
Yes. The affidavit has to be filed.
Lordship, it's fine.
Huh?
It's finished. Lordship.
Affidavit has been filed.
If my learned
As of today, affidavit,
It takes some time, lordship.
affidavit, where is the affidavit?
So,
Affidavit is not on record.
this expert award and prediction, this shows,
Hmm?
this record shows, but it, this record I'm not telling you.
No, no, affidavit,
No, 2 years file.
affidavit is not there on record.
Lordship, any other date. Any other.
Heard Mr. I heard the learned counsel for the petitioner. Also heard Mr.
Upadhyay for one.
Upadhyay for respondent number
I
one
am
and C.
permanent.
Borua for respondent number two. Mr. C. Borua submits that he has already filed an affidavit in the instant case, full stop. However, however, on perusal of the records, it seems the same is not on record. Let the matter be fixed when.
Lordship, next week, anyway, next week.
Or after vacation.
Contempt case, why after
Lordship,
vacation?
lordship.
Let the matter be fixed on 8th of 8th of April.
Let it be a 7th of
Seventh.
7th.
Or 6, Lordship.
Okay, 7th.
Lordship,
7th.
1, 6, okay, 6. Lordship, possible, Lordship.
6th.
Lordship, one more.
No, what is there in the affidavit? Whether it can be resolved and the next day.
No, some point is there, that is the Lordship.
It can be. He's saying it can't be. So what's
No,
the
no,
point of
Lordship,
keeping?
law is very much clear. Law is very much clear. Even there is order is there in contempt. There no clarification is required. I will be satisfied, Lordship. Lordship, one more. Lordship.
Okay, okay, 6th.
One more thing, Lordship. Lordship, this I did petitions, Lordship, which was disposed of. That record is required, Lordship. As because, Lordship, some in their stand, some dispute is there. Some
Then it will take some time to dispose it of.
Lordship, that's why, Lordship, that record is required, Lordship, as because some documents is there. Record it being on 6 seconds to be sent for record if required. So, Lordship, Lordship may
So it will need some hearing then. It will need some.
No, Lordship, I am saying, Lordship, there is some documents there. In earlier, Lordship, in the year 2022, they approved my pension, but did not release. But now, Lordship, there is stand taken, Lordship, in 2024. From 2024, they are releasing and they are saying that no, earlier whatever approved, they did not say.
No, what was the direction of the court?
Lordship.
Direction of the court was.
Lordship, in this case, Lordship. Lordship, direction is that, Lordship, to Lordship, kindly come into page 9, Lordship.
No, what is the order?
Order, Lordship, that's I am saying. And direction, Lordship, that is page 11, paragraph number 4, Lordship, before going into these directions, there is an order is there. In this, during this, Lordship, on that day, Lordship, on 28/4/2025.
Okay, I will put the record, raised it to place the
Lordship.
record of WPC number.
WPC number, Lordship, 3386/2023.
Record, along with this case.
Lordship. Lordship. Highly obliged, Lordship.
27 hearing.
Madam, today it will not be possible.
It is related to land acquisition matter, but the matter is maybe unlucky, never reached mine. Earlier 3 occasions also, Honorable Sanjay Mandhi, my lord, he asked me to upgrade. When we upgrade, then also some advocate came from Kerala, they were whole day they were arguing.
Some other day, it give a date when do you want to?
7th April.
7th April.
Before that, my lord. Or first is Thursday, nee?
Let us have it after reopening, madam.
Second.
Reopening.
No, my lord, again, my lord, also let us try on 7th when it possible.
A lot of matters will be there before holidays. Holidays will be on
7th.
from 9th only. 9th, 10th holidays.
19 holiday.
So after reopening, madam, that's why otherwise it
As
will
your
not
lordship,
be.
please, my lord. I don't know, my lord, this matter never reached my lord to argue. But my lord, matter is relating to 1962, from 1962.
Yes, 2019 matter, yes. This is also
19
2019 matter.
Because earlier, my lord, your lordship will see the judgment, earlier this petition is allowed. But instead of, my lord, paying the compensation amount, they
Then
have
it became
passed a My lord,
We'll fix it up sometime in
speaking order, 23rd of April.
23rd of April. Okay.
23rd, Lordship,
Okay.
Mr. Pujari have some problem on 24th. Lordship.
24th is not a hearing date, it's Friday.
Then we'll fix it up on
On
21st,
28,
আমার
28,
problem আছে।
28, 28.
We have also some problem, my lord.
After then 30th.
Yes, my lord. No, my lord, let it be on 28th, my lord.
Now, if you have
Not- not
problem,
30th.
if you have problem, then we'll fix it on 30th.
No, my
Yeah,
lord.
we don't want
let
to.
Let it be on,
we
later
don't
on,
want you
I'll
to
be
have
having
problems.
28th, my lord.
28.
28, yes.
But then you won't be able to come. Then what
No,
happens?
my lord.
Okay, 28.
28.
On the prayer,
But it never is, that is the problem, my lord.
the prayer of the learned council.
I'm tired of
appearing
appearing.
appearing for the parties. Let the matter be fixed on 28th of April.
আপনারা affidavit দিয়া নাই. You have not filed affidavit. The DCS filed the affidavit. They have not filed the affidavit, my lord. The
And the affidavit
respondent
will be
number one,
required.
my lord, commissioner has not filed any
Now, if
affidavit.
they haven't filed, we'll go with that without the affidavit.
Available in the record. Lordship.
That statement may be recorded, my lord, because I have earlier
No,
requested.
they
have
if
not
they have,
filed again.
2019 matter now affidavit, it's not required. Whatever is
DCS
there,
filed the affidavit, DCS filed the affidavit, but they have not filed the
whatever
affidavit.
is there on the record, we'll go with
Yes,
it.
my lord. And my lord, for the third time, the person has to come to court. Earlier, my lord, such a nice order was given by Honorable Justice Prashant Daka, but my lord, they did not carry out. Again, my lord, we have to come.
Okay, we'll try to hear it on 28th.
Oblige, my lord.
28 and 29.
But in this case, my lord, issue is, my lord, very simple, my lord. Date of birth, my lord, 56 initially it was recorded, subsequently 66 also recorded. But there is recovery order is there. In view of the tendency of this dispute, my lord, neither he has received the, my lord, retirement benefit, nor the salary, nor the pension, my lord.
So we'll fix it up some other day.
30th April, my lord. I have already discussed with Nayak.
30th April.
Yes, my lord.
Okay. Heard Mrs. So-and-so, the learned counsel appearing for the petitioner, and also heard Mr. You were there?
For two matter.
Uh,
That's not two.
Respondent number 2, on the joint prayer of the parties, let the matter be fixed on 30th of April.
Oblige, my lord.
31.
My lord, dismissal from service some other day, my lord, it will require some.
Hmm?
The petitioner has been dismissed from service with predetermination of guilt. So matter is fixed for hearing today, but due to paucity of time, I humbly pray that matter may be taken up after reopening.
After the evening. When do you want it?
There is one date set.
After Bihu. After Bihu.
On 23rd, my lord, April.
23rd, lot of matters have been fixed.
As per your lordship's convenience.
Can it be on 5th of May? Heard Mr. J. Patwari, the learned counsel appearing for the petitioner, also heard Mr. T. Chutia, the learned additional senior government advocate for the respondents. We'll stop under joint prayer of the parties, let the matter be fixed on 4th of May.
Okay.
5th of May. 5th of May.
Yes.
Here on a hearing day.
Yes, ma'am. Deeply obliged, ma'am.
32.
Yes, Mr. Deori.
Termination from service, your lordship.
Huh?
Hearing matter, your lordship.
When do you want it?
After Bihu, your lordship.
Any
day after Bihu.
Heard Mr. T. Deori, the learned counsel appearing for the petitioner, also Mr. T. Chutia, the additional senior government advocate on the joint prayer of the parties, let the matter be fixed on 7th of May. 7th of May.